versus Mark Goins, Trey Haggard, Jonathan Scometti, docket number CT-1579-19. And we are here this afternoon to take up several motions that are set for today. And those motions include the defendant's motion to dismiss, the defendant's motion for summary judgment, plaintiff's motion for summary judgment, and plaintiff's motion for leave to make amendments to the second amended complaint. Before we get started with the oral arguments, we're going to go ahead and if we could ask each party or person to identify themselves. We do have a court reporter present. So let's start with plaintiff's counsel, Mr. John Harberick.
Good afternoon, Your Honors. John Habenreich here on behalf of the plaintiff.
Okay, thank you.
Good afternoon, Your Honors. Matthew Peterson on behalf of the plaintiff.
All right, thank you, Mr. Peterson.
Good afternoon, Your Honor. This is William Ballou here on behalf of all of the defendants.
Thank you, Mr. Halou.
Good afternoon, Your Honors. Zachary Barker of the Tennessee Attorney General's Office on behalf of the defendants.
All right, thank you, Mr. Barker.
Good afternoon, Your Honors. Robert Wilson, also here for the defendants.
Okay, thank you, Mr. Wilson. All right, also present on the call are Marvin Williamson with the AOC, and we have Ms. Kelly Turner, who is the Shelby County Circuit Court Clerk for Division 1. We have myself present, Felicia Corbin Johnson, Circuit Court Division 1. We have Judge Susan Cook, and we have Judge Barry Tidwell, who we serve on the panel for this case. Are there any preliminary matters that we need to take up before we get started? And let's start with the plaintiff's counsel, Mr. Harberick.
Just two short logistical things, Your Honor. First thing is I would ask a little bit of leave for the court, given the fact that there are so many overlapping issues that sort of go between the different motions. Myself and Mr. Peterson are prepared to argue different pieces and different motions, but there may come a time where one of us needs to defer to the other and let that person jump in and handle the argument. I would ask permission to do that, and I don't think defendants have any objection to that.
Okay, Mr. Wilson, any objection?
Judge, this is Will. I'll be arguing for the defendants, and
Okay.
Mr. Wilson, Mr. Barker don't know, but I may turn it over to them if I just get confused. We have no objection to multiple people arguing for plaintiffs.
Okay, and then I'm assuming that we'll have that rule for the defendants as well. If there needs to be some overlap in terms of the argument, the court will accommodate that, assuming that that's okay with Judge Cook and Judge Tidwell. Judge Cook, Judge Tidwell, any issues with that?
None.
No issue.
All right. Okay, very good. Any other preliminary issues for plaintiff?
Your Honor, we had, and we have discussed this with defense counsel as well. We have a suggestion for sort of the way to proceed through those motions, given that so much of this is overlapping issues, to suggest to the court if they're so inclined. It was our idea that perhaps we should take the more procedural or logistical issues first, so standing and mootness, which is raised by the defendants, and then the motion to amend, which is raised by plaintiffs. Handle those issues first, and then we can move on to the substantive motions for summary judgment. Defendants have their motion and plaintiffs have their motion. As I say, this is just a suggestion, but myself and Mr. Hellu discussed this and thought that might be a good way to proceed, but obviously leave it to the panel to decide.
All right, so let me make sure I understand. So plaintiff and defense counsel are in agreement in terms of proceeding with the motion to dismiss first. And then is it the plaintiff's motion for leave to amend before taking up the summary judgments, or did I not get that correct?
That's right. That's the split we would ask about. And I think I'll let Mr. Hellu speak to it if he needs to, but I think the motion to dismiss the standing issues also also overlap with their summary judgment as well. So we would take that as a piece.
So, Your Honor, that's what I was going to say. There's a bit of a legal justification here. The motion to amend is what we prefer to have heard first. There's a bit of case law out there, John and I have discussed it, that basically says if there's an outstanding motion to amend, it ought to be disposed of prior to any other dispositive motions. And so we would prefer it go first. I don't think I need to have a separate argument on standing and mootness because it is contained in our motion for summary judgment. It is dispositive of all the issues as well. And so kind of what I had envisioned was the motion to amend first, then our motion for summary judgment, then their motion for summary judgment. And I think John's nodding. I think that's what we had come to.
Absolutely fine with plaintiffs as well.
Okay, so I'm sorry, I just want to make sure I'm clear and the panel is clear. Are you recommending the motion to amend first before the motion to dismiss?
Yes, Your Honor. And if we could, I'd like to collapse the motion to dismiss into our argument for summary judgment because it's the same argument pursuant to two different standards. One's a little stricter than the other. If it meets Rule 56, it certainly meets Rule 12.
Okay, Judge Cook or Judge Titwell, any questions or concerns, comments?
No, I think that makes sense.
Okay, all right, very good. So then we'll take up the motion to amend, starting with the plaintiff, and then we will move to the motion to dismiss, defendant's motion to dismiss and summary judgment, given that there's some overlap with different standards pursuant to Rule 12 and Rule 56. And then we will finally take up the plaintiff's motion to dismiss. All right. Mr. Hilo, any other issues preliminary before we get started?
It wasn't a preliminary issue, but John and I have discussed also it may be a post-hearing issue, the idea of a pretrial conference, kind of getting that on the calendar instead of just kind of proceeding straight to trial without seeing each other again.
Okay, well, we can certainly take that up at the conclusion of the motions, okay?
Cool. Thank you, Judge.
Thank you.
All right, thank you. Well, having got those preliminary issues out of the way, why don't we go ahead and proceed? Mr. Harborick, you may proceed, sir, with the motion to amend.
Thank you, Your Honor. May it please the court, John Hobdenreich of the Nashville Bar here on behalf of the plaintiff, Pamela Moses. We have filed our motion to amend really in order to try to take this logistical, procedural, kind of confusing issue off the table. What claims are in, what claims are out, what statutes are we looking at? To our mind, and as I will discuss, we have been litigating these claims out in the open, both sides, throughout the pendency of this case. So we don't see anything new here, and frankly, candidly, we didn't see a need to amend. We believe that the behavior of the parties, the pleadings, everything that had been filed showed that everybody was on the same page about which claims we were pursuing. And it wasn't until we got the response to our motion for summary judgment where defendants said, hold on a second, these claims aren't in the second amended complaint. This jury claim is not in there, that we thought, well, that's not right. We've been litigating this for 2 years. Both parties have. And so rather than get bogged down in this, we thought, look, the cleanest way to do this is to file a very sort of limited set of amendments to our second amended complaint. We're not asking to file a third amended complaint. We're not asking, we're not adding parties or deleting parties. We're not adding a bunch of new paragraphs of stuff. Really, all we're doing is we're cleaning up some of the statutory citations because with the law change, one of the sections that was at issue got moved to a new section. So we're cleaning those up, which probably needed to happen in any case. And then we're just sort of like making clear, look, to the extent there's any confusion about this jury issue, the free and equal elections clause claim, let's just spell it out in the complaint. That way, now the complaint is cleaned up for purposes of trial, it's cleaned up for purposes of appeal, and we don't have to worry about this anymore. So that's why we filed this motion. We really didn't think we needed to. That's why we hadn't filed it before now. But defendants raised it in their response to our summary judgment motion. And so we very quickly said, well, if this is going to be an issue, let's just go ahead and file a motion to amend and deal with it and get it out of the way. So that's why we filed it. Again, we really do think all these claims are very fairly, squarely within the second amended complaint. And as I'll talk about in just a second, it's very, very clear from the conduct of the parties, the legal filings, the deposition questions, all of this stuff that this jury claim issue that we've moved for summary judgment on, we've been litigating this for years. And so we think that there's no prejudice here, given all that history, and that we should just move forward with the limited amendments. So
Yes.
I
So,
will. I'm sorry. Go ahead.
no,
I
I was
apologize.
no. So in terms of the second amended complaint, are you arguing that the jury issue that's raised by whether or not there was a guilty plea or a jury verdict was inherent in the second complaint, that was part and parcel of the second complaint, and therefore it did not need to be laid out in detail, but to clear up any issues now, you want to amend the second complaint to clearly assert that position?
That's right, Your Honor. And so I'll be very specific. We have a claim that there is a constitutional violation of we're calling it the Free and Equal Elections Clause. That's Article 1, Section 5 of the Tennessee Constitution. We have two Free and Equal Election Clause claims in the second amended complaint: a facial challenge and an as-applied challenge. So those are already in the complaint. If the court remembers, this came up in context of the motion to dismiss. This was the manipulation of the electorate claim. So the stuff in the second amended complaint about the King of England used to, way back in the day, used to decide these people could vote and these people couldn't vote. And it was a real manipulation in terms of who could and couldn't vote that led to, in the United States, when we started doing our own state constitutions. North Carolina did it first, and then Tennessee did it as well. We included this constitutional language about free and equal elections. And it's really it's meant to be a restraint on government power. It prevents the government from manipulating the electorate in a way that the King of England used to, years and years ago. That's why that's in there. So we already brought those claims. They were discussed in the second amended complaint. They were discussed in the motion to dismiss. The court discussed them in the motion to dismiss order, leaving those claims in. Really, the only issue I think the defendants are raising is, okay, you brought those claims, but you didn't say jury. That's not in there. And with respect, it's the clear text of the Tennessee Constitution. It says suffrage shall never be taken away except upon conviction by a jury of some felony previously ascertained, et cetera, et cetera. So that language is in the clause. We cite the clause in the complaint. We have claims based on that clause. That's why we're saying we think this is already in the second amended complaint, but just out of an abundance of caution, if we need to clarify, let's clarify. What I want to add to that is it's not just us saying that it's in the second amended complaint. It is the fact that defendants themselves have recognized that we are bringing this claim. So we put this in our moving papers. We referenced it in, I believe, our original memorandum, and again in our reply. But one of the key things that you can look at is that last year, over a year ago, when we were litigating, if the court recalls, the Attorney General filed a motion for judgment on the pleadings, trying to say, look, I need to get out of this case. There's no standing here. And then that went up on an interlocutory appeal. During that whole time, the defendants actually filed a brief recognizing we filed our brief first and said, hey, we have a claim in here that Ms. Moses wasn't convicted by a jury. Therefore, when her initial right to vote was stripped from her, when she pled guilty, when that was stripped from her, that was a violation of the Free and Equal Election Clause. And that's our claim. We put that in our response to their motion, and they recognized it in their reply on that same motion. And I'm happy to put that up on the screen if the court would like to see it. But this was July of 2024. So the defendants actually said, that they believe that they are summarizing our argument as plaintiff maintains her injury is traceable to the attorney general because he issued these opinions without distinguishing between those convicted by a jury and those convicted by a guilty plea. That's in the defendant's moving papers. So they recognize that that's the claim they were bringing. And then they say that the other provision contains no conviction by jury requirement. So they are actually like arguing with us about this claim. So that's in their papers, and that was over a year ago. Subsequent to that, that was before we did any depositions. That's before 90% of the documents were produced in this case. That's before our expert reports were served. That's before they served their expert reports. So again, the idea that this is somehow a new claim, that it wasn't in the complaint or they didn't know about it, that's just demonstrably false. It's very clear we've been litigating this for a long time, which is, again, why plaintiffs were just continuing on with the case. Everybody's on the same page. We know what we're litigating. And it wasn't until we got their response that we thought, well, this is odd. They're saying we didn't raise this, but we've been actively litigating it for a long time. So I'm happy to go through, and frankly, I would, if the panel will permit me very briefly, I have a couple of slides, not to talk much, just to show you some excerpts of some of the paper in this case. With court's permission, I'll put that up on the screen briefly.
Okay, that's fine.
Okay. So can the court see this? Everyone see this PowerPoint?
Yes, we just have to look closely, but we can see it for the most part.
Okay. And I'll just go through these very quickly. This is just sort of a history of how these things were brought up in the case. This is December of 2022. This is our original discovery requests. And we asked specifically about people being convicted via plea bargain or versus trial. And we distinguished all people convicted of felonies in 7 versus 8, a specific subset, people permanently disenfranchised, asking about whether they were convicted by plea versus trial. There's been some discussion, and I'll get to in a second, about whether or not we raised this particular statute, 4021-12. The defendants say, oh, that hasn't been raised in the complaint. And that actual statute is not in the original Second Amendment complaint. And that's one of the things we've decided to try to add back in just to clear this up. But again, we've been asking about this since 2022. That's the original discovery requests. It's very clear what we're pursuing there. This next slide, this is a subpoena to TDOC in 2023. And again, we're asking about what is the manner of conviction here, guilty plea versus trial. That's very clear. Defendants moved to quash the subpoena. We had a whole round of briefing about it. But again, it's clear that we were trying to get at this distinction between these two things because it supports this claim that we brought, this jury conviction claim. In 2024, we got an answer from defendants. They have an original answer, and then this is the subsequent answer. They themselves cite this statute, 4021-12, that they say in their briefing, well, they've never raised this. We weren't on notice that you were challenging this or that this had anything to do with anything. But they themselves raised it in the answer. And as I'll show you in just a minute, this 4021-12 also, along with the jury stuff, keeps coming up again and again and again during discovery. And so the idea that we've never raised this or it's new to the case and somehow it's just not true. It's been a big part of this case for the last 2+ years. So that's the defendant's answer where they raise it. This is what I was talking about before. This is last July. So we talk about in our response, we say that this doesn't account for the language of the free and equal election clause. And we put in bold, except upon conviction by a jury. So we talk about this theory that you cannot be disenfranchised under the plain text of the Tennessee Constitution unless you've been convicted by a jury. So that was our response. And the defendants reply, they recognize this claim. This is what I was just reading from. They talk about our sort of conviction by a jury claim. And they say, no, actually, there's this other provision, Article 4, Section 2, that doesn't contain a conviction by jury requirement. So again, they were engaging with this argument. They recognized that this was an argument we were making. Shortly thereafter, basically the same day, if you remember, we talked a lot about search terms and what search terms we wanted. And eventually the court granted our motion to compel and they had to run our search terms. If you look at the search terms that we ran, we have, except by conviction by jury of some infamous crime. We have all these jury terms, and we have that statute 402112. Those were explicit search terms that we asked for because they were going to support our jury argument. And similarly, when we did our 30.026 topics, these are topics that we deposed the coordinator about. Again, topic 2, whether a felony conviction by a jury, as opposed to conviction by plea agreement, is a prerequisite to denying the person the right to vote. We have all these questions about eligibility to vote, initial disenfranchisement, 402112, jury convictions. That's in the topics themselves. And then when we get to the depositions, this is the actual deposition back in March, I asked, this is the 30.026 deponent for the Secretary of State. We talked about conviction by a jury as opposed to conviction by a plea agreement. The woman who was designated as the 30.026, I also took her personal deposition a few days prior to that. Basically what happened is she adopted most of her testimony from the first day and said, yes, this will serve as the 30.02 testimony. So you can see I asked, hey, on Tuesday, we talked a little bit about this. Is that right? Right. And we established that the Division of Elections has never done any research about this, has not reckoned with the very plain language in the Tennessee Constitution. Again, we don't distinguish whether the conviction was by a judge or by a jury. This is us exploring our claim that we have been clearly bringing. And again, when I asked these questions during the deposition, there were no objections to those questions. I asked them, I got answers, and we moved on. Following up, and I think this is really maybe the clearest proof that this is just a non-issue, whether or not we raise this claim. This is defendant's deposition of Ms. Moses. During that deposition, and I'll just be candid, I'll speak a little informally here. Going into the deposition, my position was, look, we're bringing this jury claim. They know we're bringing it. We know we're bringing it. I said to my team, I anticipate that their defense on this is going to be waiver. They're going to say, Miss Moses, when she pled guilty, she waived her right to jury. And therefore, she waived all these other things, and this constitutional provision doesn't apply. I sort of anticipated that I think that's going to be their argument. And when we get to the deposition, lo and behold, that's what they ask about. So they are asking Ms. Moses questions designed to support that waiver argument. They ask her about her waiver or her conviction paperwork, and they go through and they talk about the waiver language in there. There's long questions about what did you waive? Do you remember talking to the judge? You waived your right to a jury, is that right? And during that deposition, I knew, Mr. Wilson knew, Ms. Moses knew, everybody knew what was happening there. They were setting up their response because they knew we were going to file this claim. Similarly, when we disclosed our experts, so this is a little bit later, Dr. Holloway, she's our historian expert. She has a whole section of her report about why that conviction by a jury language is in the Tennessee Constitution. She talks about the Constitutional Convention of 1870 and all of the press and all of the contemporaneous statements around that. There's no reason for any of that stuff to be in the report, and it's a lengthy section, unless we were bringing this claim that you cannot be disenfranchised unless you're convicted by a jury. That's why that's in the report. So we put all that in the report. Our other expert, Dr. Baumgartner, he's our statistical expert, He has a whole section of his report breaking down conviction by jury versus conviction by plea bargain. And unfortunately, that like person by person data doesn't exist in Tennessee. So he used tried and true statistical methods to come to a number. And he basically said, essentially, it looks like 90+% of people in Tennessee were convicted by a plea bargain rather than convicted by a jury. And he explained how he got to that number. So this is all leading up to defendants. They have their experts. And they get our expert reports. They have a chance to digest them, respond to them in however manner they choose. And they also knew we were bringing this claim. That's why they deposed Ms. Moses the way they did. And so we did all that. And then, as expected, we file our motion for summary judgment. And in our motion, we say the free and equal election clause says, unless you're convicted by a jury, you can't be disenfranchised. That wasn't a surprise to anybody. In response, the defendants make the waiver argument, the one that we predicted. Everybody sort of knew that was going to be the response. And lo and behold, that's what they did. They said, "Lo, she waived it." They cited to her deposition the same questions that we sort of anticipated. So again, I say all this to say this issue, we have been actively litigating it and discussing it and arguing it on both sides for a year, 2 years, 3 years. I mean, you go back to 2022, which is our original document requests and our original interrogatories. This has been a live issue for years. And this is why we never believed there was any reason to amend here. We were trying to get on with the case. I say all that to say that the reason this is all relevant to our motion is because the standard here on a motion to amend is that motions to amend, leave to amend, shall be freely given. And we've cited cases, I know your honors are familiar with all that case law. You're supposed to freely allow people to amend. Really, the only time you don't allow people to amend is if there's some sort of prejudice to the other side. It really comes down to prejudice. And I'm sure Mr. Helou will talk about undue delay and all those things. But I want to point out here, there is no prejudice. There cannot be any prejudice here because the reason is they knew about this claim and they actively litigated it. That demonstrates that there's no prejudice. And when you look at their response to the motion to amend, you can see that they can't articulate any prejudice. They said, well, we would have asked other questions. What other questions? You asked all the questions that you needed to ask Ms. Moses to file your response. And how do we know? Because they filed the response. It contains everything they want to argue. There is no undue delay here. I explained why we didn't move to amend until now. And frankly, what our position is, we filed the motion. We don't think really it was necessary, strictly speaking, but we've gone ahead and filed it. We think as a matter of course, let's just clean this up. It's fairly limited amendments. We filed the proposed second amended complaint, and I'm happy to show it to the panel if you all would like to see it. It doesn't change very much. It adds in a reference to this 112 statute that wasn't originally in there, just to make it abundantly clear. Honestly, there's probably 5 or 6 other statutes we could add in because Tennessee's felony disenfranchisement regime is kind of all over the place. There's a whole bunch of different statutes that interact. There's stuff in the criminal procedure section of the code. There's stuff in the elections section of the code. There's a whole bunch of statutes that could get in, could be in there. But since they raised it, you didn't say 112 in the complaint, even though they said it in the answer. Fine, let's put it in there. Let's spell it out in detail, and we can just move on. I will stop there. I'll let I know Mr. Helou will want to address the prejudice and the timing and those kinds of things. And I'd respectfully request a chance to reply, but I think I'll stop there and just say this issue has been going on for a while. It's raised in the second amended complaint. Very clear the parties were aware of it. We're actively litigating it back and forth. The idea that this is some sort of surprise just is demonstrably untrue. And the idea that there's anything that would need to happen after this other than let's just go on to trial, that's exactly what would happen. There is nothing else that needs to be done after this. We'd filed a amended second amended complaint. We'd filed a new one. And we'd move on to trial. And that's really all that would happen. So unless their panel has questions about that, I will stop there and let Mr. Helou respond.
Judge Cook or Judge Tidwell, any questions so far?
I did have a question. It may have been answered at least partially, but my question was going to be if the idea is that this is, I use the word frivolous. I don't use it in the strict sense of the term, that it was not needed, then why file it? In other words, if the answer to their motions was that, look, it's been pled, my question was going to be, then why did you feel the need to file it? You've gone into that a little bit towards the end of your colloquy. If that's the answer, then that's fine.
And Judge Tidwell, that's a great question. I think setting everything else aside, we probably would have said, look, we don't need to file it. Having filed it and having the fact that the statutory numbers have changed, we think it's the better course here, now that it's been filed, to just go ahead and grant it, since there's no prejudice. That way it's cleaned up, both for trial purposes, but really just as importantly for appeal, because I think no matter who wins here, I think there's going to be an appeal, I suspect. And so I think taking this issue off the table, putting it in the complaint, and saying, all right, we know that this jury thing is in the complaint. We know 112 is related in some respects. That just takes it off the table. We don't have to argue about this at trial. Hopefully we don't have to argue about it on appeal. So we think the better course here is just to grant the motion so we can move on to the substance.
And then my second question is, if we side with you and we were to grant the motion to amend and the defendants say, well, because we've not been on notice as far as a pleading, your argument, I understand, is that, look, there's been on notice since day one because of the citations, and I'm sure we're going to get some citations to rebut that argument. What if the defendants say, well, if that's the case, then we need more time because we would have responded differently? What would your argument be to a thought of, well, maybe they do need more time and maybe this is not ready for trial based on the fact that maybe there are questions that they want to answer. And I understand you've addressed a little bit of that, but I don't discount the citations to the record that you've given, and I haven't heard their argument, although I've read the papers. But do you not think there would be anything to a claim of, well, judges, if you're going to let them amend, even though we have seen some of this language throughout the pleadings, there are some things that we might have done different or argued different or pled different. What do you say to that, assuming that's about to come up? And I may be making an assumption.
No, I think you're right, Judge Sidwell. And I think it's been, we have a good working relationship with opposing counsel, so we've had this discussion, in our meet and confers. What I would say is, if you look at the briefing here, there is no demonstration that anything more or different would need to have been done. For example, when we filed this in our reply, they say, well, we didn't have the transcript for her other guilty plea, but that's not true. The transcript is attached to the second amended complaint. That's just wrong. They say, well, we would have asked different questions during Ms. Moses's deposition, but that's not true either. You look at the deposition questions, their main argument against this claim is waiver. They have this other sort of technical legal argument. Well, there's this one statute that says this, and there's this statute that says this. But they were prepared to make the counter argument against our motion, and they did make it. And they asked the questions they needed to ask Ms. Moses. If they want an affidavit from her or something like that, I'm sure we can get that. But they have not pointed to anything new they would need to ask or anything new they would need to do, and the reason they can't is because they did know about these, and so they were prepping for them. The other thing that they point out is that, well, we would have done this statistical analysis between jury convictions and plea bargain convictions. But again, that's a red herring. We asked for that data, and I showed the court, right? We asked for that data from defendants. We asked for that data from TDOC, and everybody said that doesn't exist. That data doesn't exist. And so we told our statistical expert, listen, that data doesn't exist. So do your best, use accepted statistical methods to come to an approximation of plea bargain numbers. That's what he did, and he supported it. And again, they got that expert report, and they absolutely could have asked their expert, whose report came later, to respond. Go and poke holes in his methodology if you want, or if you think you can find the data somewhere. I know plaintiffs have asked for it, and we've said we don't have it, but if you think you can find it, go for it. They could have done all that, and some of it they did. But again, this idea that there's something more that they would have done or could have done or needed to do, That's just not borne out by what happened here. They did everything they needed to do or wanted to do to try to deal with this claim. And we lay out in our reply, we lay out, here's why they say, oh, we needed to do something differently, or here's the prejudice, here's what we would need to change. And point by point, we say, nope, that one's not true. They have the transcript. Nope, that one's not true. That data doesn't exist. They're claiming we need this data. They are the ones who told us it didn't exist. We would have asked different questions. Nope, that's not true either. Here's the transcript. They asked every single question repeatedly. So you look at the briefing, to answer your question, Judge Tidwell, directly, they did everything they could think of to respond to this. There is nothing new under the sun here that they would need to do, and they have not pointed to anything in their briefing different than what they would need to do. So that's the long version of the answer. The short version of the answer is these are minor adjustments, recognizing the reality of what the parties have already been litigating. We've cited cases where trial judges have said, listen, I've looked at the deposition testimony. It's clear that the parties are already aware of these claims. They've been litigating them. So I'm going to allow an amendment just to recognize the reality of what the parties have been doing. We've cited cases to that effect. There's a car wreck case that talks about it, and the plaintiff raised this comparative fault thing. That was like during trial. That one case that we cited was during trial, and they permitted an amendment to recognize the reality of what the parties have been litigating. That's really all we're asking here. It isn't new. There isn't anything else to do other than do the amendment and move to trial. I mean, I think that's the long and short of it.
All right, thank you, Mr. Harbor. Judge Cook, any questions?
No, thank you.
Okay. All right, Mr. Helu, would you like to respond?
Yes, Your Honor, if I may. And I'm going to start by saying sorry for throwing about 400 pages of stuff at you guys. I didn't realize how much it was until I printed it all out and put it on my desk for this argument. So we appreciate you guys taking the time. The other thing I want to say, and I don't want to harp on it too much, but there's this idea that we're lying. That the Attorney General and the Secretary of State coordinator elections are play acting surprise, I think was the word, or I think also he used feigning surprise. And I think he reiterated today that it's just not believable. I want to say I've been doing this for 20 something years. No one's ever actually said that in a pleading about me, but I do want to say no one is lying here. We mean what we say. And that brings me to framing this. And it's two questions, Your Honor. It's not just one. The first question is it already there? Is an amendment required to consider these issues? Depending on how that question gets answered, we move to the second question, which is if it isn't there, should an amendment be allowed? And that's the Rule 15 question. To start with the first question, and I think the answer is pretty short. No, of course not. It's a meticulously drafted, almost 30-page complaint. It cites very specific statutes, the permanent ban statutes, the permanent ban of 4 categories of felons that cannot seek reenfranchisement. Every cause of action, all 10, states a cause of action for why those permanent ban statutes are unconstitutional. Only those statutes. Not once is 40-20-112 mentioned. Not once is general felon disenfranchisement mentioned. As to the free and equal elections clause, not once is the word plea used. Not once is the difference between someone who pleads versus someone who's convicted by a jury is used. Your Honor, 7 lawyers, 6 from one of the largest firms in the world and 1 who teaches at Vanderbilt University. We took them at their word, and their words are very clear. It is 10 causes of action that challenge the permanent ban statutes. They do not challenge felon disenfranchisement, and they do not seek to challenge the plea versus jury difference. Now, where does that leave us? Well, they say, and I will state that when someone challenges one of my complaints and says, you didn't plead this, my response is usually, see paragraph 25, that's where it is. See paragraph 28, that's where it is. See paragraph in this complaint all the way up to 130. That's where it is. They don't say that. It's because it's not there. So what do they say instead? They say, well, pay no attention to our pleading. Pay attention to these discovery requests and other filings. As to the discovery requests, as your honors full well know, we objected to those requests because we said you're seeking information on things not pled and they are not relevant. Your honors' response was the standard for what's discoverable is quite broad. Turn it over. I'm summarizing. It took more pages, but that was basically it. So yes, we complied with the overly broad discovery obligation and responded to their discovery requests after being told to by this court. That, however, according to the Tennessee Supreme Court and the Tennessee Court of Appeals, does not add claims to their complaint at all. The Tennessee Court of Appeals in no uncertain terms says discovery requests and other pleadings do not add claims to a lawsuit. Claims are noticed in a complaint. Here, claims aren't just noticed in a complaint. They are noticed in 4 different complaints that have been filed in this lawsuit. And this last complaint, the second amended complaint, is the operative complaint. It is the one we are looking at, and it certainly pleads no claim for the constitutionality of 40-21-12. And it contains no challenge to the disenfranchisement of felons who are convicted by a plea agreement versus by a jury. And I think, Your Honor, to wrap this part of the argument up, again, the simplest counter argument would be to say, see paragraph 140. They don't, because it's not there. He did say that this jury idea appears in counts 1 and 6, which is their free and fair elections claim. Your Honor, it only appears because they quote the entire clause from the Tennessee Constitution. And in fact, what they do in the rest of that cause of action is they apply that clause to, quote, Tennessee's permanent disenfranchisement statutes. They don't apply it to all felons. They don't ask the court to apply it to felons convicted by only plea agreement. Those clauses of action contain about 7 paragraphs, and every one of those paragraphs contains the words Tennessee's permanent disenfranchisement statutes. None of those paragraphs contain the words, my client pled, was not convicted by a jury, and thus it was unconstitutional to deprive her of the right to vote. Now, let's take it a step further. Even if we get past that, let's look at their prayers for relief, because these attorneys very carefully drafted those. And here's what they asked this court to do. First, they asked this court to declare the permanent ban statutes as facially unconstitutional. They don't say anything of general felon disenfranchisement. They don't say anything of jury versus plea, which they would have needed to, because it would only apply to felons who had been convicted by jury, not to ones convicted by plea. Second request for relief. A declaration that the permanent ban statutes are unconstitutional and invalid as to Ms. Moses. Again, same 2 issues. Third request for relief. A declaration that Ms. Moses is eligible to have her right to vote restored. Again, no reference to general disenfranchisement or plea versus jury. The fourth is a mandatory injunction directing defendants to restore Ms. Moses' right to vote. The fifth is an injunction enjoining defendants from, and this is key, preventing Tennessee citizens from voting, quote, related to any of the permanent disenfranchisement statutes. Not to all felons, just the felons convicted of those permanent disenfranchisement felons. The sixth is to notify all felons, including those convicted under the permanent disenfranchisement statutes, that they may seek to have their right to vote restored. The seventh, to engage and take additional steps to ensure affected citizens are informed of their restored rights. And the eighth, any other such relief this court deems appropriate. In other words, in 10 causes of action, in 8 claims for relief, not once did they seek to challenge the constitutionality of 40-21-12. And not once did they ask this court to restore the voting rights of people that had pled guilty to a felony, as opposed to those who have been convicted after. So, Your Honor, we think the answer to the first question is pretty clear. It's not there. It's not there, and now we flow to Rule 15. And before I go to Rule 15, is any questions from the panel that I can address on that first issue?
No, I don't have.
No question.
So now we get to Rule 15, and Rule 15 is, John's right. It is a fairly liberal standard that courts have applied in the past. But there's a test. And the parts of the test that we'd like to focus the court's attention on are prejudice, unexplained delay, and futility. On prejudice, I have to address some of the things that John said, because I think they're not quite true. First, they are seeking this amendment after the close of discovery. Your Honors, we would certainly, I can't imagine any lawyer doing their job wouldn't have asked for the transcript of her guilty pleas for all three of her felonies. Now, John casually says they have it. Well, it's attached to the complaint. No. In fact, I think two of her guilty pleas happened at the same time, and that transcript is attached to the complaint. The third is not. There is no more clear evidence that we did not know this was a claim. Of course, we would have asked for that third transcript if we had known this was a claim. That's borderline malpractice. Secondly, he keeps saying that they, in discovery, asked for the number of felons convicted via jury against the number of felons convicted via plea. And our response, as he correctly stated, is pursuant to our discovery obligations, we don't create documents in response to your discovery. We provide you the information and documents we have. We don't have that. Now, is that information reproducible? Of course. Every felony conviction has a transcript in this state. Every one of them. We could have gone to county clerk's offices and we could have put forth the effort to create the information. We didn't need to create it to respond to discovery. That's not our obligation under Rule 26. But if we thought we were defending that claim, would we, because we needed it to defend, have put that information together? It certainly would have been on the menu of things we'd have looked at. But we never bothered. And do you know why we didn't bother? Because it wasn't a claim in the lawsuit. Those two things are the simplest to name. And Your Honors, of course there's prejudice to not knowing that information. What if in the transcript of her first felony plea, the judge had said, you're about to lose your right to vote. You good with waiving that? Well, that seems dispositive of the issue. And we don't know if that happened or not. I've seen some criminal pleas, and some judges do say it, some judges don't. Tennessee Supreme Court says they don't have to, but some do, some don't. It just depends on the judge. So, Your Honors, to pretend, and that's just too simple, to pretend we wouldn't have sought other discovery is, first, it's presumptuous, and second, it's just wrong. John kept referring to the idea that they predicted our argument and we made it, and it relates to waiver. Well, yeah, when we saw their motion, we didn't want our argument to solely be this isn't a claim. We did our best to respond as a matter of law. And the waiver argument's not that hard to predict. You know why it's not hard to predict? Because it's true. Of course it was predictable. Anyone would predict it, mostly because she did it. She waived. But that said, us making that argument in a motion certainly doesn't mean we knew all along. So prejudice, yes, the discovery deadline is passed. What else is passed? Well, the expert deadline is passed. Much like we may have efforted more information in discovery, if we squarely knew this was a claim, if there was cause of action 11 and 12 that set these up, would we have sent our expert on that exploration trip to get these numbers? He put up some felony conviction numbers on the screen during his argument. What he failed to mention is those are federal numbers. Neither party is here today with any estimation of state numbers. And do you know why we're not? Because we were never asked to, because we didn't think it was relevant. We were litigating the claims that this lawsuit, their complaint said they wanted us to litigate. Would we have efforted at least a sample size specific to the state of Tennessee? Of course. Of course. And we'd have a statistical analysis. Now we can't. The third prejudice, and this may be the biggest. Dispositive motion deadline has passed. Yes, you have our counter argument on their dispositive motion. That is not an affirmative request for a judgment on our part. That's just a response to them. If you deny their motion, that does not grant us motion. We still go to trial. Now, we may go to trial pretty confident, or you may deny it on other grounds, but that doesn't let us test it legally. First. Second, no one briefed anything about 40-20-112, the general felon disenfranchisement. That does not appear in our motion for summary judgment. It does not appear in their motion for summary judgment, and it does not appear in either of those motions because it was not an issue in this case. We do not need to be going to trial on whether or not a bare bones statute enacting a constitutionally authorized power is constitutional, because the answer is easy. Of course it's constitutional, but we never got a chance to brief it. Now, Your Honor, we mentioned it in the motion to dismiss, and Your Honor's reaction in the motion to dismiss was, at this stage, pursuant to this standard, we don't think we can speak to it, and we're going to let you develop your record. And that was after Your Honor asked explicitly, and I think it was you, Judge Corbin Johnson, that asked John, are you challenging general felon disenfranchisement? Would you like to amend your complaint? John's response was, we are not. We are challenging permanent ban statutes, not general felon disenfranchisement. Your Honors made note of that in the opinion on the motion to dismiss. It was noteworthy enough for Your Honors to put in the opinion. So there's your prejudice. I personally think the inquiry should end there. But if it doesn't, Rule 15, another reason to deny a motion to amend, there's unexplained delay. And unexplained delay, it overlaps a bit with prejudice, but it contains a bit more. The first prong is, have the plaintiffs known the entire time of this claim, or is it something they discovered in the course of litigation? Now, Your Honor, the key to some of these is understanding that oftentimes people amend complaints to add facts, and people amend complaints to add causes of action. Now, if a plaintiff through discovery discovers additional facts, they may want to add a cause of action. If they discover additional facts that fit within one of their current causes of action, they may want to amend just to add facts. Here, these plaintiffs have had knowledge of 40-20-112, general felon disenfranchisement, from day one. Ms. Moses has known from day one she was disenfranchised pursuant to that statute. And so there is no allegation of we newly discovered this, that's why you should let us amend. It doesn't exist yet. The second thing the courts have looked at is they said, okay, look, when you're not looking at just adding facts, when you're looking at causes of action, we need to know, have the parties been litigating the facts that would underlie this cause of action? In other words, is this new cause of action, or is the test for it overlapping with the test for all the rest? If it is, bring it on in. If it's not, don't. Your Honor, here, they do not overlap. The constitutionality of 40-20-112 has nothing to do with the constitutionality of permanent ban statutes. The constitutionality of a conviction as a result of a plea versus a jury has nothing to do with the free and fair elections clause application to the permanent ban statutes. It just doesn't. So adding a new theory at the last minute that was known the entire time but not told us. The third one, and this was at Justice Cope when he was just a judge opinion, is, does the amendment require reopening discovery? It's just like the prejudice problem. I've already talked about it. I don't want to talk about it again for the second time. But as then Judge Cope said, that alone establishes undue delay. And so, Your Honor, they've met all three prongs of undue. So we have independently dispositive of this motion. Prejudice exists. Secondly, undue delay. Third, futility. Your Honor's already said this in the motion to dismiss opinion. They said, to the extent they're challenging felon disenfranchisement, when we asked them, they said they weren't, but to the extent they are, the Constitution can't violate itself. And our Constitution envisions felons being disenfranchised. Period. It's a really short clause. Your Honors, it would be futile to allow this amendment because the claim fails. The claim fails as a matter of law for the exact same reasons that Your Honors already said.
I'm sorry, could you explain that, why you believe the claim fails? If there wasn't.
Yes, Your Honor.
Okay.
The challenge to 40-2112, general felon disenfranchisement, is authorized. Our Constitution explicitly states the state may deprive people convicted of an infamous crime of the right to vote. It is unambiguous. Your Honors, in the motion to dismiss opinion, said, to the extent you are trying to say to the plaintiffs that that provision of the Constitution violates another provision of the Constitution, that claim must fail. Because the Constitution can't violate itself. That's the language Your Honors used in your opinion. And all 40-2112 does, it's really short. It's not a long statute. It does exactly what the Constitution authorizes. It deprives all felons of the right to vote upon conviction. Period. And so it is the bare bones enactment of the constitutional provision that Your Honors already said couldn't be unconstitutional. And so, Your Honor, just by virtue of the order on the motion to dismiss, it's futile to add that claim now. It will fail.
Okay, Mr. Hilo, could you just briefly address the issue with regard to the jury, conviction by jury versus guilty plea, and how in the state's opinion, how in the defendant's opinion, this is or is not an issue?
Sure. And it may just be simpler, and it's a good question because they are two different claims they're looking to add here, not just one. And it's simpler just to go to count one. It starts at paragraph 88 of the complaint. And
Okay.
paragraph 88, and I'm not going to read the whole thing, but it quotes Article 1, Section 5. That's all it does. Doesn't say anything else about it. Yes, Your Honor.
Okay, let me get to that section, please. You said paragraph number 80?
88.
88.
It's on
And
page
it's-
29 of the second amended complaint.
Not the proposed, but the one that was actually filed on October 13th, 2022?
Yes, Your Honor.
Okay, page 30,
29.
oh, sorry, 29. Paragraph 88. Okay, do the other judges need some time?
No, I'm fine.
Okay.
Okay.
Okay, yes, sir, you were.
Yeah, we'll walk through it together. Paragraph 88 quotes Article 1, Section 5. Not much commentary there. It does add that it's been there since 1796. But that's all it does. It makes no argument. It makes no claim. It quotes the provision. Paragraph 89. It says, as the Tennessee Supreme Court has noted, the same constitutional provisions that guarantee the right to vote also charge the state with ensuring elections are free and equal. You will see there is still no mention about the Tennessee Supreme Court saying anything about jury convictions versus pleas. Paragraph 90. Tennessee's permanent disenfranchisement statutes permanently deny thousands of Tennesseans their constitutional right to vote in violation of the free and equal clause. Your Honor, Tennessee's permanent disenfranchisement statutes is a defined term. That defined term means the statutes that permanently disallow certain felons from seeking reenfranchisement. Again, it has nothing to do with jury conviction versus pleas. Paragraph 91.
Well, okay, let me stop you there because that's where I'm a little bit confused, because if the legislature has passed a statute that permanently disenfranchises one because they have been convicted of a felony, as is in this case, but the felony conviction was not by a jury, it was by a guilty plea, is it inherent in the Tennessee Constitution, which states that the right to suffrage cannot be, and I don't want to misquote. I was going to ask Mr. Harbinrick to pull it up. Could you pull that section up, Mr. Harbinrick?
It's in paragraph 88. It quotes the entire Article 1, Section 5.
88. I don't see it. Oh, yes. Okay. Let's see. It says here, elections shall be free and equal, and the right of suffrage shall never be denied. So the suffrage is the right to vote, shall never be denied to any person entitled thereto, except upon conviction by a jury for some infamous crime, which would generally be a felony, previously ascertained and declared by law, and the judgment thereon by a court of competent jurisdiction. Okay, so that is the language that I was looking at. So is it inherent in the Constitution, Article 1, Section 5, that right should not be denied unless there is a conviction by jury? So is it implicit when the plaintiff asserts that her rights have been violated if the court enforces 4029-204, which permanently disenfranchises her because she pled guilty to a specific crime outlined within that statute, that would be in violation of our Constitution and therefore not enforceable because she was not convicted by a jury?
So let me.
So when we're looking at whether or not the amendment to include language regarding the jury is necessary, isn't it implicit within the Constitution that if the Constitution says one thing, but the statute that permanently disenfranchises individuals in Tennessee says something different, and these individuals who are permanently disenfranchised were not convicted by a jury, but they pled guilty, why would that statute be enforceable? So I guess my question is it implicit or inherent that the plaintiff is raising this argument with regard to conviction by jury versus guilty plea?
And you got exactly where I was going to go with my answer. So there's two answers to your question. The first answer is there a colorable claim to be made? Maybe. We think it was waived, but fine, maybe. The question today isn't, is there a colorable claim to be made? It's, what's the claim made? And Your Honor, here's the simplest answer. We know the pleading requirements in Tennessee. It's a notice pleading state. It's a little different than some other places. Notice pleadings. Here's what we know wouldn't work. A complaint that quoted a constitutional provision and then had a single paragraph that said, and so what you did was unconstitutional. We know that's not notice because you haven't told us what we did. All you've told us is there is this provision that we all know exists. And then you're like, hey, you violated it. Well, that is what courts have called a bare recitation of legal conclusions. You got to put some meat on the bone in a complaint. You got to give us notice. How was it violated? All right. And so what's the easiest way to see what this complaint's saying? Well, it's to read it as a whole. And most specifically, it's to say, what do the next few paragraphs say are the reasons that you have violated that constitutional provision? Right? And they did exactly that. They more than met the notice pleading standard. And here's what they gave us notice of. They gave us notice that Tennessee's permanent disenfranchisement statutes, as applied to everybody, they never once say as applied to people convicted of a jury, as applied to every felon convicted of those statutes, is unconstitutional. And if you read paragraphs 90, permanent disenfranchisement statutes, says it right there. 91, permanent disenfranchisement statute, how it starts. 92, these statutes were used, and here, this is important, were used intentionally and disproportionately to disenfranchise Black Tennesseans. Your Honor, there is no evidence in the record that there is a higher percentage of Black Tennesseans who plead than are convicted by a jury than white felons. That evidence has never been tested. And to prove that it disproportionately affects Black people, if you're focused on the jury issue, you would need to show that more Black people as a percentage are pleading than white people. Otherwise, it's not race-based. It's based solely upon whether or not someone pled or someone went to trial. And we see no such allegation in this section. And so when we get to 93, just like the King of England in the 1600s, we're manipulating the electorate by permanently disenfranchising. Not by disenfranchising people convicted by plea versus jury, but rather permanent. The permanency is the key. Paragraph 94, permanent disenfranchisement statutes. You will not find the word plea anywhere in this cause of action. It's because they weren't challenging you. They may have been in their minds, but they never gave us notice. And without giving us notice, it's not a claim. The court has been as clear as day on that. And I don't think anyone reading paragraphs 88 through 94, the mental gymnastics that would be required to get to that is about pleas versus juries, you at least got to say the word, don't you? And so, yes, Your Honor, is there a colorable claim to be made? Sure. I don't think it's the right one, but I think it's there. Has it been made? Unequivocally, no. Would we have done different discovery had it been made? Unequivocally, yes. Have we demonstrated? Yeah, go ahead, Your Honor, sorry.
Say, well, given the significance of what is being alleged here in terms of the alleged violation of Article 1, Section 5, by the enactment of these permanent disenfranchised statutes for individuals who plead guilty versus being convicted, if that is the case, and the court is certainly not prejudging, but if that assertion is true, that has far-reaching ramifications for individuals living in Tennessee who have been disenfranchised, regardless of their race or color or demographic. If the Constitution says one thing and the statute says another, again, whatever decision this court makes, if the court takes up this issue, it's going to have far-reaching ramifications on either side. So in terms of the futility, if the court were inclined to allow the amendment to specifically state that the violation of the permanent disenfranchised statutes, which have allegedly disenfranchised Ms. Moses, are unconstitutional because they violate Article 1, Section 5, specifically because Ms. Moses was not convicted of a crime. I don't think that there's any dispute about that she pled guilty to the crimes which are before us. So if that is the case, what would be the harm? What would be the prejudice in allowing that amendment to go forward? And then in terms of discovery, what discovery would be necessary? Because it's uncontroverted that she did not plead, that she was not convicted. So in terms of a waiver, I'm not even so sure that a waiver of her rights to be declared infamous and to lose her citizenship would even be a factor. If what the plaintiff is alleging with regard to this distinction, which is a really, really, really important distinction, if that is true, what would be the prejudice?
Your Honor, the prejudice to allowing it now is what I was referring to before. There have been no factual development because no one's gone out and explored it as to numbers, any of the underlying facts, as to numbers of people who have pled, of the race of the people who have pled, of any sort of information.
Well, let me ask you this, and I didn't mean to cut you off, but this is not a class action lawsuit. This is a lawsuit involving one plaintiff. And if we know that the fact is that she was not convicted then why would that historical data be relevant?
Of course, because Your Honor, the claim, as we just read together, is a race-based claim. They speak to how this has affected Black Tennesseans at a high rate. That's the claim. I'm not, we can't rewrite their claim. That's what they said.
Okay.
And so obviously relevant to any such claim would be the numbers of Black Tennesseans versus white Tennesseans. Your Honor, I'll also say that there are basically 5 claims in this lawsuit, and they are repeated twice each. One as applied to Ms. Moses, one facial. You may be right that the as applied challenge is not a class action. None of the challenges here are class action. But facial challenges to succeed, you must prove that in all circumstances that statute is unconstitutional. And so it would get back to, there is some discovery that would need to be done that no one here is even saying they did it. That's the worst part. Even John is saying we don't have those numbers. He's saying we asked, they said they didn't have them. They didn't try and go effort them. They just used federal numbers. Irrespective of whether they would have, I can tell you as the lawyer for the defendants, we would have explored trying to get those numbers. We would have, and that's the prejudice. And then we'd have had our experts look at them, and that's the prejudice. And then we would have filed a dispositive motion, which would have kept us all from having to go to trial for 5 days, because it is a legal issue, and we have tested it with this court. And because they waited 6 years, knowing that the law hasn't changed in those 6 years, none of the facts have changed in those 6 years. They waited 6 years to make that amendment. They waited until a month before trial. And that's why we can't do all those things. And so, Your Honor, that's the very definition of prejudice. And it overlaps with the very definition of unexplained delay. And here is the second part of the answer that I want to make sure we say out loud. This panel not allowing this amendment does not foreclose that challenge in the future. What this panel has been charged with doing is deciding this lawsuit. There may be future lawsuits that can make that challenge. And so nothing we do is going to handicap anyone going forward. It's about what we're going to try in a month. And trying to add a new theory that requires new factual development 30 days before trial, that's a little rough.
Yes, and I agree, and thank you for that explanation. When I think about Rule 15, of course, the court considers the factors, but the court puts a lot of emphasis generally on the prejudice, because the court, and I just speak for myself because we have a panel and we will deliberate, but this court has traditionally, for the last 11 years, approached these amendments from the perspective that we want both sides to be prepared for trial. And sometimes we set trial dates, we have scheduling orders, and given the circumstances of the case, all the lawyers are working hard. You have a very, very difficult job to do. Sometimes cases just are not ready. But I've always taken the position that I want both sides to be prepared. And I'm looking at the prejudice. What is the harm if the amendment is granted? In terms of this case, this was filed in 2019, but I just want to correct one thing. Yes, it's been on file since Ms. Moses filed pro se in, it looks like, well, in 2019, but she also filed her amended complaint pro se on June 2nd of 2022. And she was not represented until sometime in 22 when, no, I'm sorry, she filed her amended complaint. Okay, there were 2 filed on the same day, it looks like, in June. Mr. Harper, correct me if I'm incorrect, but
June 2nd, what was June 30th?
June 2nd and June 30th. So Ms. Moses filed, okay, thank you, Ms. Kelly. Ms. Moses filed 3 petitions, and then it looks like the first one filed by the attorneys was in October of 2022. So, and we've all been working very diligently to get this case prepared for trial, but it just seems that yes, you're correct in that perhaps another plaintiff could bring the same claim, but what would be the benefit to, in terms of judicial economy, to the state of Tennessee, to the citizens, to Ms. Moses, or any other individuals who may be affected or aggrieved by being permanently disenfranchised? Why should we start over, have a new case filed, have a new panel appointed, and start that process over again when we are so very close? The plaintiffs are arguing that the state, the defendants have been on notice because these, while they may not have been pled, there are many references throughout the pleadings that this was going to be an issue of whether or not you could permanently disenfranchise an individual such as Ms. Moses if she had not been convicted of a crime. So I understand that the amendments could have been made sooner, that it may require some additional discovery, giving the defendants that the opportunity to at least have that discovery. But look at the flip side. Look at, you know, and I'm looking at the efficiency and the judicial economy. If the case has to be refiled with another plaintiff, look at the time and resources that are going to be expended. And then most importantly, if the plaintiff is correct in their assertion that you cannot permanently disenfranchise someone pursuant to the statute unless they are convicted, look at all of the people that are going to suffer in the meantime who would not have the right to vote. So as I'm thinking about what's fair, what's proper on both sides, these are some of the issues that I'm considering. So thank you for allowing me that opportunity. Anything else that you want to say before you conclude, and we'll go to Judge Tidwell and Judge Cook?
Two quick things. Unless Judge Tidwell, Judge Cook, anything? Okay.
I have no questions.
Okay, just two quick things I want to say, and it's partially to respond to what you just said, Judge Cornjohn. The best cases, I remember when I was cooking for Tom Weisman, this case is not the best vehicle for this question, and I'll tell you why. There's nothing clean about it. When this case goes up on appeal, because I'm pretty sure whichever side is on the wrong side of the final judgment is going to file that notice of appeal, there's going to be standing issues. There's going to be mootness issues because this plaintiff hasn't engaged the new process for reenfranchisement. There's going to be other justiciability issues that you've seen in our pleadings. This is the least clean vehicle ever for deciding a legal issue. Secondly, whether it happens in this case or another, the additional discovery is going to have to happen. It's going to require probably another deposition or two. The additional expert disclosure is going to have to happen. It's not saving time to do it here. If another plaintiff sued tomorrow, it would take the exact same amount of time to do that discovery. It's not more efficient to do it here. It's a new claim. We're going to have to litigate that new claim from scratch. If an amendment's granted that adds two new claims, 40-21-12 and the free and fair elections clause, we got to litigate those. And we got to litigate them from square one because we haven't, the state certainly hasn't been litigating them. If you look at the state's discovery requests, they're not in there. And so, maybe you cut off a month or two. Do we really want to prejudice one side in hopes of saving a month? And so I don't think there's any economies to doing it here. I think having a cleaner vehicle for this challenge should be more important. One where standing and mootness aren't an issue. One where the plaintiff has engaged the correct process. Because what if we go through all this extra trouble and the court comes back with, well, there's no standing, we're vacating the judgment. Well, then all of those people you just talked about are 2 more years away from getting their right to vote. Whereas if one of them engaged the correct process and started anew today, they're much closer, much, much closer. So while there may be this desire to get an answer, I would temper that desire with what that rush may mean. The desire to get the answer may end up costing us more time than saving us. The only final thing I'll say, and I only say this because there are some cases that say I need to. Apparently, there's this argument that if someone files a motion to amend and you say prejudice, but don't ask for more time, in case the motion's granted, that you've waived the right to appeal the denial or the grant of the motion to amend. So what the state will ask the court to maintain the appellate issue is, if the court is inclined to grant this motion to amend, we would like more time. We would like to reopen discovery. We would like, and to be quite frank, Your Honor, you've now heard plaintiff's counsel say over and over again, they've already litigated the issue. We think it ought to be one-way discovery. We think we should reopen discovery just for the defendants, and we should be able to complete the discovery we need to complete. We should then be able to have supplemental expert disclosures, and we should then get a new dispositive motion deadline to test those claims before trial. And so the state, in the instance of this court being inclined to grant the motion, would ask for those things.
All right, thank you, counsel. Just one quick thought. We cannot speculate about what the Court of Appeals or the Supreme Court may or may not do.
Sure.
But we do know that I think that there was one instance where there was an appeal taken on a standing issue, and the panel was affirmed. So to put the notion out there that there are problems with standing or there are problems with the complaint not being clean, I mean, those are just allegations. That's the defendant's position. But there are vehicles all along the way since this process has been going on to seek review if deemed necessary. And I can only think of one case where that review was taken, and again, the panel was confirmed. So we have all been working very diligently. We've been thinking about these issues very carefully, and we can't speculate, but we have to take our case as it is. And then whatever our esteemed colleagues at the Court of Appeals and the Supreme Court decide to do, then we trust that they will make the right decision. So having said that, Judge Cook, do you have any questions?
No, thank you.
All right, Judge Tidwell?
No questions.
Okay.
Thank you, Your Honor.
All right, thank you so much. Now, Mr. Harbinwick, you wanted a brief reply?
Yes, Your Honor. And
Okay.
I'm going to try to be judicious here. I'm extraordinarily frustrated with this presentation because it is simply assertions by a lawyer about things that are not accurate. This idea that there needs to be more discovery of these plea versus jury convictions. Again, I want to go back here. We asked for that. And I think one of the most important things Mr. Helou said during his presentation is we never bothered, because that is what happened here. They knew we had this claim. They knew we were litigating this claim. And in fact, in their reply filed on July 10th, 2024, over a year ago, they said, plaintiff is bringing this claim that it doesn't distinguish between those convicted by a jury and those convicted by a guilty plea. But here's why that claim is wrong. The idea that they didn't know this claim and they weren't litigating it and they didn't have every opportunity to do whatever they wanted is just false. And I put a citation in our reply to the idea of judicial estoppel. I'm not saying it applies directly here, but the rationale for that is you stop parties from taking inconsistent positions during litigation. You can't say one thing and lull the other side into it, and then all of a sudden wait till the end and say, wait, no, that's actually not true. That is exactly what defendants are doing here. They made the calculated decision not to ask their experts to analyze this issue, not to go seek these documents, not to analyze any of the statistics, which, as Your Honor pointed out, are not relevant to whether Miss Moses was convicted by a jury. She wasn't. It's not relevant to the plain text of the Tennessee Constitution. The Tennessee Constitution says by a jury, period. This is the exact same claim as the Supreme Court case, Gaskin. The Gaskin case, which we've cited, both parties have cited, was a question about whether or not the Tennessee legislature, when they passed a new law trying to retroactively disenfranchise a whole bunch of folks, that was challenged under this same provision, the Free and Equal Elections Clause, Article 1, Section 5. The Tennessee Supreme Court says you may constitutionally disenfranchise felons subject to the provisions of that clause. This is the same claim. In that case, it was about the language that says previously ascertained. You have to be convicted of a felony previously ascertained. That is a limit on what the state can do to disenfranchise people. Here, same claim. The state is limited in how it can disenfranchise people by the words conviction by a jury. This is the same thing. It is a simple and straightforward textual analysis, which we raised in our complaint. The idea that this is a race-based claim is not true. Read the second amended complaint. The race-based stuff is the equal protection claim. There are facts that are common to lots of them, but that is a deliberate misreading of the claim. That claim is about a manipulation of the electorate. Could it have been clearer? Absolutely. And I take that on myself. I was working on this case by myself as a civil lawyer who was just getting into doing pro bono work, taking over a pro se case. It was not until a year and a half later that my colleagues from Arnold and Porter came in. So could I have drafted that a little clearer? Sure, absolutely. But the idea that we cannot say, this is the plain language of the Constitution. Miss Moses was not convicted by a jury. Therefore, she cannot be disenfranchised. That is about as straightforward a claim as you can bring. And the idea that they need to do more depositions and more discovery, please do not take that at face value. That is a decision tactically that they made. You look at our expert reports that were disclosed. You look at the history of the filings here. They decided to sit on this and then at the last second say, haha, nope, actually you haven't raised this claim. And now they're just manufacturing reasons to avoid going to trial. They're trying to avoid the merits of this claim. That is what is happening here. The assertions of additional discovery and additional experts, for what? There is no discussion in their briefing about how this new data that they said that they didn't have when we asked, they said they didn't have it. But now they're saying, oh, we can go get it. What? How is that fair? I truly don't understand how you can take the position in response to discovery. Sorry, that data doesn't exist. We're not going to give it to you. Go ask TDOC. TDOC says, well, we don't have it. In the meantime, they've moved to quash our subpoena because we're trying to get the data. Now, at the 11th hour, as an excuse to try to not let us go for this claim, they're saying, well, now we're going to go get the data. That's not playing fair ball. It's really not. That is a tactical decision not to pursue these issues with their experts. They absolutely could have asked their experts to go get that data and analyze that data. They could have asked their experts to analyze this in their reports, because remember, they had our expert reports first. Our expert reports gets into all the jury stuff, all the conviction stuff, all the plea bargain stuff, both on the statistics side and the history side. They had all of that. They could have decided to respond to it, but they didn't. They didn't. And the reason they didn't is because they wanted to do this. What they're doing now is to try to sandbag us. And now they're trying to make up reasons to delay the trial or to avoid the merits. I am frustrated. The idea that, again, 40-21-12, I wrote it down. Mr. Hellu said, that's nowhere in the briefing on summary judgments. That's not true. It's in our motion for summary judgment. We cite it repeatedly. So I ran out of room writing down things that are, I think, accidentally inaccurate. The idea that we were never asked to get this data, also not true. I showed you the discovery requests where we asked for that data. We asked for it 3 years ago and we're told it didn't exist. So that now the idea that we're fast forwarding and now they're concerned about getting the data, or now they think it's important after telling us for years it didn't exist. This is litigation tactics. And I'm sorry to say it, but it really is. This is a simple question. What does the text of the Tennessee Constitution in Article 1, Section 5 mean? It says conviction by a jury. This court, all we're asking for is a declaration that that provision means what it says, just like in the Gaskin case. The Article 1, Section 5 means what it says. In that case, the Tennessee Supreme Court said previously ascertained means you had to have had that crime listed as infamous at the time you were convicted. You can't go back and retroactively make people infamous. Here, we're saying it says what it means. That is in the complaint. We cite the text of the Constitution, and sure, it could have been clearer. But again, Mr. Hellu is right. We are a notice pleading state. We are not a describe every single possible iteration of every single claim in your complaint state. I could have done a better job writing the complaint. That's true. But that's why we're here on a motion to amend, to clean this up and to say, look, the parties have been litigating this. Mr. Hellu keeps saying that they haven't been litigating it. All objective evidence demonstrates that they absolutely have. And I go back to what he said earlier. We never bothered. We never bothered to develop this data. We never bothered to have our experts review it. And there's just no demonstration in their briefing about why any of this is necessary. They're just conjuring up reasons to delay the trial or to delay resolution of this issue. I urge you not to credit that, because there is no explanation in their response to our motion about why it's actually prejudicial. What did they think they could prove? What did they think would be different? He talked about the transcript from Miss Moses's conviction from 20 years ago. That is entirely irrelevant here. And I'll tell you why. She was convicted, and then she restored her rights many years later. That conviction is off the table. It doesn't have anything to do with anything. The two convictions that are issue, that transcript is attached to the complaint. Mr. Hellu says, oh, I'm aware of certain plea bargains where a judge says, oh, you're going to lose your right to vote. Well, where is that? That's just Mr. Hellu talking. That's not in any discovery in this case. That's not in any filings in this case. That's not in the statement of undisputed facts. It is just manufacturing things to try to generate prejudice. Again, this is a simple and straightforward claim. So you look at our complaint, again, with respect to Mr. Hellu, there's lots of stuff about permanent disenfranchisement in there. There's also lots of stuff about the 451,000 Tennesseans that are disenfranchised. That group is a much larger group. It is clear when you look at the complaint, we are challenging both the permanency piece and the initial disenfranchisement. If you look at our claims, for example, the cruel and unusual punishment claim, that was dismissed. That is a permanency claim. That's about the permanency. We were saying it is cruel and unusual punishment to permanently deprive someone of their right to vote. On the other hand, the procedural due process claim, he wasn't told about this during a repeat plea colloquy. That violates procedural due process. That's a disenfranchisement, initial disenfranchisement claim. It looks at the initial moment of disenfranchisement. Both of those theories are in the complaint. It doesn't make sense unless you have both of those theories in there. So the idea that this isn't pled, again, Mr. Hellu has said it could be more specific. I could have written it better. Sure, that's fine. Where we are now is a motion to amend, to clean that up. So the question is there any prejudice? Is there any, delay here? And the last thing I'll say on the futility piece, because I think Mr. Hellu said there's prejudice. I've talked about the prejudice. There really isn't any. They cannot substantiate it. Their claims for prejudice are absolutely undermined by the briefing, by the facts on the ground. The delay, I've explained the delay. We were lulled into, again, they identified this last July. They knew we were bringing this claim. They responded to it. They identified it as a theory that we're bringing over a year ago. That's why we didn't move to amend. Clear as day, they understand that we're bringing this claim. And the futility piece, the sort of, you can't have one piece of the Constitution undermine the other piece. That's not what we're saying. We are saying, just like in Gaskin, yes, people can be disenfranchised in Tennessee. We've never said otherwise. But if you are going to disenfranchise people, you have to do it in compliance with the words in the Constitution. That's what the Gaskin case was. And we're saying the same thing. Yes, you can disenfranchise people. but you have to follow the text of the Constitution. There's absolutely no reason to not let that claim go forward. It is simple. It is straightforward. We briefed it. They briefed it. There is no other discovery that needs to be done, notwithstanding their arguments on the other side of that. And we think the simplest thing to do is grant the motion to amend, clean this up, and move on to trial. We can deal with this issue on the motion for summary judgment because it's fully briefed. Both sides have fully briefed it. I feel like I'm repeating myself at this point, so I'm going to stop unless there are any other questions.
All right, thank you. Judge Cook, any questions for plaintiff's counsel?
No, thank you.
All right, Judge Titwell?
No.
All right, I would just like to say very, very briefly, because I was the original judge on this case and back in 19 when it was filed as the petition. And again, the court has been very, I want to make sure that I use the right word, but I would just say worked with both parties, because when this case was originally filed and Ms. Moses sought her reinstatement of her citizenship, the initial position from the state of Tennessee and the district attorney's office was that she was still serving her sentence, that she was on probation, so she was not eligible for reinstatement. Rather than dismiss the case, the court held the case until such time as Ms. Moses had completed her probation and the terms of her conviction. And then when Ms. Moses came back to ask the court to reinstate her citizenship, it was only at that time, and I want to say that was sometime in 2022, that was the first time that the issue came up with regard to her permanent disenfranchisement. So that was 3 years that the issue was not raised. So I want us to be mindful when we're thinking about how this case has how it evolved and what has transpired over the last 5 years. So I think that that's important to just think about because, again, the court was allowed the state of Tennessee as well as the district attorney's office to go forward and advance those claims or arguments that she was permanently disenfranchised. And at that point, that's when Ms. Moses filed her amended petition challenging that the state's position. And in fact, in her original amendment, which was filed on the 2nd of June, Ms. Moses raised several bases as for judicial review. Tennessee statutes 4029-204, which is specifically at issue, 4020-112, and 4029-105 are vague and overbroad and in violation of the legislative intent and the spirit of the creation of the law. 2, the permanent disenfranchisement of Pamela Moses was unconstitutional under Article 1, Section 16. The permanent disenfranchisement of Ms. Moses was unconstitutional under Article 1, Section 11, ex post facto, that the state of Tennessee violated Pamela Moses' due process under Article 1, Section 8, that this state of Tennessee violated her substantive due process right, violated her procedural due process right, and then did not provide Ms. Moses with adequate notice of permanent disenfranchisement. So this case has taken many different turns, and the court appreciates all the hard work on both sides. Thank you so very much for the arguments on the motion to amend. Why don't we take a brief recess, let the court reporter take a recess, and then we'll come back maybe in about 5 or 10 minutes, maybe about 5 minutes, and then we can take up the motion to dismiss.
Thank you, Rob.
All right, let's talk about 5.
Judge, can we go into private session, just the judges?
That'll be fine. What we will do is, Ms. Kelly, is it better to put them in a waiting room or just
Yeah,
have?
in a waiting room.
Okay, lawyers, we're going to put you in a waiting room. If you bear with us.
Attention everybody, the judges are ready. I will be bringing them in shortly.
Hey, John or Matt, just to confirm something, could y'all hear any of the conversation during that break?
No. Good.
I was wondering.
We would have said something if we'd been able to hear anything.
Well, it was one of those, I'm on two different machines and it's the kind of dumb lawyer mistake a dumb lawyer like me would make. So I wanted to make sure I was muted everywhere.
Okay. Okay, welcome everyone back. During the recess, the panel has decided that in the interest of time, it is 5 Central and 6 p.m. Eastern. And of course, Judge Cook is on Eastern time, that we would like to limit the arguments, as the Court of Appeals does, to 15 minutes per side. And if you would like to reserve some time for rebuttal, then you may certainly do that. So we'd like to take up the motion for summary judgment and the motion to dismiss. We're going to combine those, so 15 minutes per side, and then we will move to the plaintiff's motion for summary judgment, and that will be 15 minutes per side as well. Is that agreeable to everyone?
Absolutely, Your Honor. Thank you.
All right, very good. Because I know that you all have things that you need to do this evening, so we want to make sure that we adjourn at a reasonable time. So with that having been said, Mr. Hilo, are you going to argue for the defendant?
I am, Your Honor.
Okay.
If you don't mind, before my time starts, let me figure out this screen sharing thing.
Okay.
Okay, and I am going to, I'll be honest, I didn't time this, but I'm going to do my best. And please interrupt for questions. If I could, Your Honor, I know you invited me to reserve a little bit of time. If I could have a couple, 3 minutes at the end to rebut, that would be awesome.
All right. So great.
Okay, well, I'll get right down to it. I'm going to focus on the summary judgment standard because, as I said earlier, if something meets the Rule 56 standard, it certainly meets the Rule 12 standard because it's a bit more strict. And we are at trial, the party that does not bear the burden of proof. And so at summary judgment, according to the Tennessee Supreme Court, we can achieve or carry our summary judgment burden in one of two ways. We can negate an essential element of their claim, or we can demonstrate that they have not adduced enough evidence at this point that they can cite to in the record to prove their claim. And Your Honors, what I'm going to try and do is go through each of our arguments. And it's a structured 3-slide, our argument, their response, our reply stage. And so with that standard in mind, I want to start with standing and mootness. And standing, we all know, it requires an injury in fact that is fairly traceable to the defendants and that is redressable by the court. And mootness is related, but slightly different. It relates to the passage of time that can sometimes make a case no longer a vehicle to provide the judicial relief that the prevailing party is requesting. Here, Your Honor, there was a new reenfranchisement statute passed, and it is contained in 4029-102A. The parties agree that this has been passed. In fact, part of their motion to amend was to renumber to account for this. Now, under the new regime, Secretary of State Hargett and Coordinator Goins are basically, they're supervisory administrators. They only verify whatever a circuit court decides when someone files a petition to have their right to vote restored. The key here now is the circuit court decides every petition. Coordinator Goins no longer makes that decision. Secretary Hargett never did, but no longer supervises Coordinator Goins making of that decision. Attorney General Scrimeti, to be quite honest, has never made that decision. All he has ever done is provide legal advice. He provides legal advice to all state officials, including Secretary of State Hargett and Coordinator Goins. Coordinator Goins can take the advice of his legal counsel, or he cannot. He is not by statute. No statute binds him to what Attorney General Scrimeti may say. All due respect to Attorney General Scrimeti, of course. The key now is that not one of the named defendants registers, purges, or enfranchises voters. Ever. Ever, ever, ever. They don't disenfranchise felons. They don't re-enfranchise felons. And so, where does that leave us? Well, here's what plaintiff's response to all that is or defendant, plaintiff, sorry. They say that defendants still administer, implement, and enforce the election laws. And then they say this 2019 denial letter shows Goins caused Moses' injury. Well, not really. What the letter did is the letter was to the, the election commission of Shelby County. And the election commission of Shelby County then chose to do what it wanted to do. And in this case, it chose to disenfranchise or to not re-enfranchise Ms. Moses. I'm not sure there is a law or statute that says, we can throw the commissioner of election of any county in jail for not listening to coordinator Goins. I don't think there's any sort of punishment we could enact. Now, there could be a lawsuit, but certainly, again, the point is, it was not coordinator Goins that made the decision to disenfranchise her. He was just advising the Shelby County Election Commission. And they say the AG's opinion guides enforcement. Well, yes, the AG's opinion certainly does guide enforcement, much like any lawyer's opinion, any of their clients guide enforcement. But I don't think we want to go down the road of saying, okay, if a client gets advice from a lawyer and you don't like what that client does, you can then sue their lawyer. No such case exists in Tennessee. We don't sue lawyers for giving clients advice. We sue the people that actually do the actions that we are complaining of. And so, Your Honor, I think I've kind of swallowed up my next slide. When we're talking about standing in mootness, here they have a traceability problem. Her disenfranchisement stems from her felony conviction. It's a civil disability that comes with all felony convictions. And her lack of re-enfranchisement stems from the absence of a circuit court order, not re-enfranchisement. That is where we stand after the new statute. So no traceability. Redressability. There is no order of this court to any of these defendants that will re-enfranchise Ms. Moses. Only a circuit court order can do that. Only a circuit court order can do that. I want to repeat that. And so you could order coordinator Goins to go tell the circuit court something. Well, as circuit court judges yourselves, I'm pretty sure a lot of circuit court judges would have an issue just saying, okay, we'll do what you say. That's not what judges do. And so there is no order of this court that can fix the issue that she complains. Now, the reason it relates to both standing and mootness is because all of the things I just said relate to the passage of time, the 2025 amendment. They made the circuit court the exclusive forum for what plaintiff is seeking. And to be clear, plaintiff has not, pursuant to those amendments, applied to the circuit court. And that's why there's no circuit court order.
I'm sorry, let me clarify that.
Yes.
Ms. Moses did apply to the circuit court back in 19.
She did. And,
Yeah.
and the new statutes actually dictate what Ms. Moses should have provided the circuit court. And here it was not provided because there was no statute that listed those things. In other words, the new statute not only puts it in a new place, it actually says the process by which you should go through. And so she has not engaged that process. She engaged the prior process under a different law. In circuit court, you are correct, Judge. But this is a new process with new requirements, and she has not engaged them.
Well, let me ask a question, and I don't want to get into your time. Just very quickly, if she sought restoration under the old statute, I'm a little bit confused as to why that would not be correct.
It absolutely was correct on the day she did it. The point we're trying to make today is, if you issued an order to the coordinator of elections to restore her right to vote, his response would be, I am not statutorily authorized to do that. You can tell me all you want. I can't. Only the circuit court can. And it's interesting what plaintiff's counsel's response to this is. They say, don't make us do it because we all know how it would go. That's basically their answer. They actually gamed it out with that bullet pointed list. Okay, so she does it again. We all know what circuit court's going to decide. And so we ought to go ahead and rule on it now. Well, Your Honors, it's, again, as circuit judges, I would invite the idea that no party should be as presumptuous as to assume what a circuit court judge is going to do. You have to engage the process. And so we'd say with all that, the claims are non-justiciable. I did want to address quickly, plaintiffs probably seeing this issue have fallen back on something called indirect injury that can provide standing. And I want to be clear about what the Tennessee Court of Appeals said about indirect injury and Rutan Ram. And it was actually a state case. It was against the Tennessee Department of Children's Services. In quoting from it, an injury resulting from a third party's independent action does not satisfy the traceability requirement. In other words, if Coordinator Goins does advise someone with independent authority to do something, because that someone has independent authority, you cannot sue Coordinator Goins. You have to sue the someone. And so indirect injury won't work here. And to be clear, the road for the Attorney General they are asking you to go down is to allow parties to sue lawyers for the advice they give clients. We cannot allow that. As an attorney, I advise boards as a large part of my job. When the boards go and do something, I do not expect to be named in lawsuits over those board actions, whether I recommended them or not. We do not allow attorneys to be sued for actions of their clients. Attorney General's Committee, they've now done discovery. This isn't Rule 12.02 anymore, where the court said in the motion to dismiss, we're going to let you see if you can develop some facts. The only fact they developed is to Attorney General's Committee is he writes opinions and advises state actors. Attorney General's Committee does not make restoration decisions. He does not make disenfranchisement decisions. He interprets the law and he advises his clients. And his clients can do what he says, or they cannot. So, I now have definitely subsumed this last. Oh, sorry. That's, unless there's any questions, trying to fly through, that is the standing and mootness argument. Moving forward, equal protection. The neat thing about these is the law on everything they brought up is fairly well developed, with maybe the exception of the last argument. But equal protection, we all know what it bars. It bars laws that facially discriminate against people, especially suspect classes. And it bars facially neutral laws that were enacted and maintained with a discriminatory intent. Now, to be clear, in the Tennessee Supreme Court has not waffled on this. Disparate impact alone is insufficient to prove an equal protection claim. McClay was not ambiguous. In other words, if there's a law and it disparately impacts one suspect class a lot, it's not enough. That's not enough. And courts considering equal protection laws must always start from a place of the legislature acted in good faith. In other words, you presume that they did not intend to discriminate, absent evidence to the contrary. So, what's our argument? Easy. Our argument is the Rye standard. They haven't set forth enough evidence. In fact, they haven't set forth any evidence. They rely solely on statistics. They have not once said, here's a racist statement made to pass it. They have not come forward with an email that says, let's pass this because we really don't want Black people to vote. They have not come forward with anything like that related to these laws. Statistics, according to the Sixth Circuit, in a different case that the Attorney General's Committee was involved in, will only suffice in cases in which, and quoting, the law at issue is inexplicable by anything but animus. To be clear, that is the same standard the Tennessee state courts have adopted. Your Honors, you have already found a rational basis for this law when you considered in a motion to dismiss the equal protection claims. And you said the rational basis was to exclude some people who have committed certain felonies from ever seeking reenfranchisement. And that was rational because those people were people who had committed murder, rape, treason, or what amounts to crimes of integrity against the government, like evidence tampering. So what is their response to that? They don't really fight us. They just say, but no, look how lopsided these statistics are. And this is the statistic. 16.5% of Tennessee's population is Black. And they are 36% of those disenfranchised. So it's about a 2.5 to 1 ratio. And then they say, okay, look, we have this expert. She's a historian. And she can certainly say back in the 17 and 1800s when these constitutional provisions were passed that there were racist people and that maybe they had some racist origins. And she talks about that. To be clear, their expert historian openly admits she examined no laws after 1950, including the reenfranchisement statute. So, our reply. Disparate impact does not equal discriminatory purpose. And standing alone, disparate impact isn't enough. There is an explainable ground for passage, and I cite to this court's order in the motion to dismiss election integrity, excluding those that are unfit to vote. Now, the legislative history, there is absolutely at this stage zero evidence of racial animus in relation to this reenfranchisement regime and the permanent ban statutes. In fact, and I think this is worth pointing out, to allege racial animus is to allege that the 2006 sponsors, including Senator Harper, were racist. I worked in the AG's office when Senator Harper was a senator, and she was a civil rights leader. And I want to be clear what these reenfranchisement statutes actually did. This regime reenfranchised African Americans at a rate of about 2.5 to 1 compared to whites. In other words, when this law was passed, it allowed Black Tennesseans to vote at a rate of 2.5 to 1 compared to 1. So let's move to the last point. Even if in 1730 and then 1830, or whenever these constitutional provisions were passed, that there was some racial taint.
How much time has elapsed?
About 100 and I think it was 1836 to now.
I guess I was referring to when you started your argument.
I am on my own timing at 6 minutes.
I wrote down that the argument started at 6:04, so
Oh,
15
gosh.
minutes would be 6:19. Although there was a brief time of questioning in there, but we need to be mindful at the time.
Yeah, I will fly through even faster. Substantive due process, it is a shock the conscience standard. It's generally reserved for legislative acts related to fundamental rights. Felons don't have a fundamental right to vote. Honestly, their response is, our position is the Constitution envisions this. It can't shock the conscience to do what the Constitution says the legislature can do. It can disenfranchise felons. It doesn't have to reenfranchise them. You can't possibly say that shocks the conscience. They respond that the right to vote is fundamental. It's not for felons. It's not. It's that simple. And that the permanency is arbitrary and shocks the conscience. To be clear, in Falls, the Tennessee Supreme Court says the Constitution envisions it would be permanent, and there is no right to reenfranchisement. So it can't possibly shock the conscience. That gets us through substantive due process. Free and equal elections, as planned. It targeted the permanent ban statutes. To be clear, Article 1, Section 5 does not require reenfranchisement, period. Their response is it manipulates the electorate. Well, listen, that's an equal protection claim. That's not a free and fair elections claim. Manipulating the electorate means you're treating one group different than the other. You can't try and mask that equal protection claim because you know you can't meet the standard. Secondly, it's more lenient than the constitutional one. So their new claim is that disenfranchisement is invalid since the conviction was by a plea, not a jury. And then they say by a jury is a structural one. Well, Your Honors, that's just not true. First, this clause that they cite to was not meant to do any of what they're trying to mean it to do. It was meant to stop retroactive disenfranchisement. Secondly, she waived it. She pled guilty. She's presumed to know what the law says. And so the state didn't take it away. She literally voluntarily surrendered her right to vote. She gave it away when she pled. And to say this is a structural claim, it's just wrong. Structural claims, rights to trial by juries, it appears twice in the Constitution, and it's waivable. We all know you can waive a right to trial by jury. So you can certainly waive the civil disability that comes with it. So let's see how quickly I did that. That was pretty good. Here's the last thing I want to say of, and it'll take 2 seconds instead of summarizing. I want to bring the court's attention to something that Judge Corbin Johnson said earlier, which was, this is a big deal. We're talking about all felons and whether or not they should be reenfranchised if they pled or if they didn't plead. And a lot could be assumed here. The court's assuming that it could strike down just the permanent ban statutes, but we have to be conscious of the fact that permanent ban statutes are part of the entire Reenfranchisement Act. In other words, there was never an act just for the permanent ban statutes. They are part of how all felons get reenfranchised. They are an integral part of how felons get reenfranchised. There is no severability clause. If this court strikes it down, it's not granting felons the right to vote. It's taking away their right to be reenfranchised. All of them. The entire statute falls, not just the permanent ban statutes. And we think that's important to point out because that's what's at issue here. Right now, about 90% of felons can be reenfranchised. If this is found unconstitutional and that whole act goes away, none of those people get to vote.
All right, Mr. Hilo, I'm going to have to ask you to conclude at this point. And any questions for counsel, Mr. Hilo? No, hearing none. Okay, Mr. Harborough responds, and you have 15 minutes.
Thank you, Your Honor. Let me address one thing that cuts across every single claim here. Defendants have the standard on summary judgment wrong. They have it backwards. And I'll cite to the cases here in just a second. We didn't move for summary judgment on these claims. We moved as to one claim, the free and equal elections claim, which Mr. Peterson will address. The case law is clear, and I'm citing from Rye, which they cited also, 477 Southwest 3rd, 235. It is the moving parties, here the defendants, they have the burden of production. They must submit evidence to meet their burden at summary judgment. And this is a quote from Rye. A moving party seeking summary judgment by attacking the non-moving party's evidence must do more than make a conclusory assertion that summary judgment is appropriate on that basis. What that means is you have to submit a statement of undisputed facts and say, all right, here's the evidence at issue. Here's what they've said. Here's what their statistician said. Here's what their historian said. Here's what it said in the depositions. That's all the evidence. Now, taking all that, it doesn't meet the standard here. Defendants haven't done any of that. There's not a single affidavit attached. They could have gotten an affidavit from the Attorney General. They could have gotten an affidavit from the Coordinator of Elections. They've done it before in this case. They could have filed those affidavits along with their motion and said, here's my role that I play. See, I don't have anything to do with elections. Here's my role that I play. I don't approve things, or I don't do this, I don't do that. But they didn't do that. Their statement of undisputed facts, except for one about, I think, Ms. Moses for conviction, all the rest of them is just a list of legislators saying they're Black. That's it. That's all the evidence they put forward in support of their summary judgment motion. A whole bunch of legislators are Black, which is candidly borderline offensive. That's the only evidence they have against our
Just make your
claims
argument.
here?
You don't have to give commentary on your offensiveness or not. Just make your argument.
Certainly, Your Honor. Setting aside the offensiveness or not, that doesn't suffice as evidence that certain legislators are or are not Black. It has nothing to do with any of the claims. It doesn't get to supporting their burden of production. According to the Tennessee Supreme Court, as the moving party, they have the burden of production. They have not carried that burden on any of their claims. Not standing, not mootness, not equal protection, not substantive due process, not clear and free and equal elections. So as an initial matter, summary judgment cannot be granted here because they have not properly supported it. This is an issue, and your honors, I think, are familiar with why the statement of undisputed facts has to be laid out in that manner. When you grant a motion for summary judgment, the Court of Appeals has to be able to identify what are the explicit facts that supported the motion for summary judgment. What did the court rely upon? What evidence did the court rely upon to determine that those facts are undisputed? There's none of that here. They did not attach our expert reports. They didn't attach their expert reports. They didn't attach deposition testimony. They didn't attach affidavits. This is their motion, and it's their burden to do all that. So as an initial matter, frankly, they cannot prevail on any of their motions as to any of the claims because they didn't meet the requirements of moving for summary judgment. So setting that aside, I want to talk briefly about standing. Mr. Hellu talked about the rights restoration process and how the amendments to the statutes changed that. And their argument is that these amendments erased standing and made the whole case moot. That is their argument, right? Before the amendments, they said you have standing against the coordinator. They argued about the attorney general. Again, they have not submitted any facts supporting their standing arguments. And so again, we are basically left with bare legal allegations. But setting that aside, let's look at what the amendments did. The amendments did not touch permanent disenfranchisement except to move it to a new section and clean up some of the like numbering. But nothing about the permanent disenfranchisement statutes, the evidence tampering resulting in permanent disenfranchisement, that didn't change. 112, which we've talked a lot about today, that has to do with that initial disenfranchisement that Mr. Peterson is going to talk about, that we cited in our briefing, that didn't change, that didn't move. The only thing that changed is if someone is entitled to restore their rights under the current system, if you've paid your restitution, current on your child support, you've paid your court costs and fines, and you flatten your sentence, if you met all those things, this new system says, all right, you have to go to court. Whereas before you could file a form, you could file a certificate of rights restoration. That's what changed. That's not this case. Again, defendants keep saying, well, she needs to go through the rights restoration process. Nobody is saying that if she went to court tomorrow, that anything would be different. The statute says she's permanently disenfranchised. We are not here about rights restoration. We're not here about her going through that process. That's a different case. We are here about the constitutionality of the felony disenfranchisement process. That's why we have a 3-judge panel, because we've raised constitutional claims. So they're trying to conflate those two things. There's the rights restoration world where you apply and you file a petition and you talk to the court. That's how this case started, in fact, but that's not what this case is about anymore. So let me tell you why there is standing here and how this would work. Mr. Hellu is saying she needs to file her thing in a circuit court and go before the judge, and the judge decides. That's not the case here. What we have asked for in our prayer for relief and how this would work is, and I believe he said, the court can't order that she can register to vote. Sure, the court can. The court can say, for example, free and equal elections clause. We interpret the Tennessee Constitution to mean what it says. You can't be disenfranchised unless you are convicted by a jury. Therefore, that's our holding. We are ordering that Miss Moses was unconstitutionally deprived of her right to vote originally. And so our order says she is now permitted to go register to vote. And what would happen? She would take that order. She would go to the Shelby County Election Commission. She would fill out a voter registration form. And importantly, you would check the box that says she's a convicted felon, because she has, under penalty of perjury, she has to check that box. And she would submit that to the Shelby County Election Commission. What happens next? By statute, the Shelby County Election Commission has to send that up to the coordinator. If she checks that box saying she's a felon, and this is what we put in our briefing, and this is how it works in the statutes. If she checks that box when she's registering to vote, after this court says you can register, that application goes up to the coordinator, and the coordinator has to decide, yes, she can register, or no, she can't. The county election commission cannot make that determination on its own. By statute, they have to send it to the coordinator. The coordinator, and this is why it was the same thing before, that part has not changed. If you are a person convicted of a felony and you're registering to vote and you check that box before the amendments and now, you file that form, it has to go to the coordinator. That's why in 2019, when she tried to register to vote, the Shelby County Election Commission sent it to Coordinator Goins. They ran their system and they said, nope, so you can't register to vote. They sent a letter down and she was not permitted to register to vote. It's not the decision of the Shelby County Election Commission. It's the decision of the coordinator by statute.
Can I ask and I won't hold this against your time, but does the commissioner or coordinator of elections, does he have discretion in that decision?
He does in the case of felony disenfranchisement. So it's two different situations. It is if there is a court order through the rights restoration process,
right?
That still has to go up to him, actually, but that has to go up to him. But really, in that case, he's looking at the face of the order, and we have deposition testimony. This is another reason why this is not appropriate for summary judgment. Oh, I'm sorry.
What's the second one then?
So the second one is if she just went to register to vote and check the box. So imagine that someone.
But doesn't he just follow the statute or order? I mean, he really, in other words, it's not like people apply and he deliberates and thinks and
that actually is the case. So that's what discovery showed. When the coordinator gets and this is again why this is not appropriate for summary judgment. We have lots of deposition testimony about this process. When they get an application for registration to vote and it goes up to the coordinator, they have an internal process that includes the Attorney General's office. That was the testimony about, we have a tricky situation. I'll give you an example. So there were these cases where people who were trying to get their rights restored, but they couldn't get their gun rights back. And this is an analogy, but I'll tell you why it's important. It came up in depositions. Those folks applied to their local circuit court and they got an order, went up to the coordinator, and the coordinator determined, okay, I got to look at the face of the order. I got to talk to the Attorney General. We got to decide what to do about this individual person. And I asked, okay, let me ask a question. If you got some court somewhere telling you, hey, restore this person's right to vote, even though they have a permanently disqualifying conviction, would you just follow the court order and just restore their right? And the answer was no, I wouldn't. We'd have to look at that. We'd have to analyze it and determine whether or not that person gets their right to vote back. So it is very much a live issue. If you have a voter registration, which is what would happen here, this is what we're asking for, say that she can register to vote. She fills out the application, she checks the box, it goes up to the coordinator, they have to determine what to do. That's by statute. But again, all of that testimony around the process and discretion and who decides and what research did they do, we got into all of this in depositions. But that's not part of this filing because it wasn't brought up by the defendants. It's their motion. It's not our burden. We didn't move summary judgment on this. So that's why none of that is in the record. That's what a trial is for, to hear about that, hear that testimony back and forth, to determine, okay, what actually factually does happen here. So again, this idea that she needs to go through the rights restoration process like any other person, that's not this case. This case is a constitutional challenge about the plain text of the Tennessee Constitution, the statistical evidence. And let me touch on that because I'm running short on time here. Mr. Hellu's presentation pointed out that statistical evidence can, in some circumstances, be evidence of intent. He said, they don't have an email. They don't have an email. Well, again, courts all over this country, state and federal, have recognized people have learned not to say the quiet part out loud. They don't put in an email anymore, I'm passing this law because I don't like Black people. I'm being glib here, but that doesn't happen anymore. The law has developed such that you can prove discriminatory intent through a variety of ways. We have evidence, statistical evidence that we're ready to show at trial. We have historical evidence that we're ready to show at trial, but none of that is before the court right now. That's the whole point of a trial, is to be able to get that evidence out and have the finder of fact evaluate that evidence. Nothing is in front of this panel right now to evaluate. And we've demonstrated, we had a statement of additional disputed facts saying that all of these issues All of these factual issues are hotly in dispute. That's why we had experts. That's why they have experts. Their experts attack our experts, and they try to undermine their statistical findings, and they try to undermine the history in some respects. But again, that factual fight, that's what a trial is for. So I go back to my original point, which is under Rye, there's another case, Sons of Confederate Veterans, which is 2017 Westlaw 4842336. Very similar case. And the Court of Appeals there said appellees failed to meet their burden. Their statement of undisputed material facts contains no facts calling into question the allegations in the second amended complaint that the court previously held that, taken as true, sufficiently established standing. That's the same thing here. The court has already looked at the allegations in the second amended complaint and said they're sufficient to establish standing. If they wanted to move for summary judgment, they would have to show facts, undisputed facts, citations to the record to undermine that. Rye and the Tennessee Supreme Court says unequivocally, you cannot just rest on legal argument. You have a burden of production as the moving party, and they have not met that burden. So that position, combined with the fact that this focus on the rights restoration process and the amendments to that process, and now you got to go to court rather than filing a form, that has nothing to do with this case. We're not saying she should be able to go through the rights restoration process and being restored. What we're asking for is an order from this court saying that the process is unconstitutional under one of these theories. We touched on substantive due process. Again, we have gotten facts and discovery that shows that the Attorney General's office and the coordinators of office have never even looked at this idea of jury versus conviction by plea bargain. To us, and we intend to bring forth proof that shocks the conscience, and that there's other evidence of arbitrary processes within the within the coordinator's office around felony disenfranchisement. That arbitrariness that goes to substantive due process. We have facts and evidence to support that, but again, that's what comes at trial. None of that is in the record. None of that is before the court, and so for those reasons, both the standing challenge, the mootness challenge, those are not relevant to the claims that we have. And as to the other equal protection, substantive due process, and our free and equal elections claims, we have evidence for all that, but it's not before the court because procedurally, defendants have not raised this appropriately. And in any case, all of these facts are in dispute. And so the last thing I'll just leave that with, I know your honors are familiar, when you're at a summary judgment phase, and there are lots and lots of facts in dispute, and one side said one thing and the other side says the other thing, the default assumption is you go to trial because you have to resolve those factual disputes at trial. You cannot grant summary judgment in the presence of substantial factual disputes. And that's where we are in this case right now. And I think my time has expired, so I'll stop there unless there are any questions.
All right, thank you, counsel. Judges, should we allow a reply, or has Mr. Helu used up his time?
I think he used up his time.
Okay, all right, well then let's move on to the next motion then, and that would be the plaintiff's motion for summary judgment. And Mr. Harberick, are you arguing that as well?
That is Mr. Peterson.
Mr. Peterson, okay. Good evening, Mr. Peterson.
Good evening, Your Honor.
Okay, are you prepared to go forward now?
Yes, sir. Yes.
Okay, all right, you'll have 15 minutes. Would you like to reserve any time or?
Your Honor, I'd like to reserve 2 minutes. All
right, so I have 5:40, so we will stop at 5:53. Okay, you may proceed.
Good evening, Your Honors. Matthew Peterson on behalf of Plaintiff Pamela Moses, and I'll be addressing her motion for summary judgment. Before 1870, the Tennessee Constitution simply provided that elections shall be free and equal. Then, in 1870, on the heels of targeted disenfranchisement efforts following the Civil War, Tennesseans convened a constitutional convention and decided to strengthen the protections afforded by the Free and Equal Elections Clause, otherwise known as Article 1, Section 5. And if Your Honors don't mind, I'm going to go ahead and share a slide with the text.
Okay.
So after it was revised in 1870, it provided that the election shall be free and equal, and the right of suffrage as hereinafter declared shall never be denied to any person entitled thereto, except upon conviction by a jury of some infamous crime previously ascertained and declared by law, and judgment thereon by a court of competent jurisdiction. And the free and equal elections clause has since remained unchanged. Despite this language, Ms. Moses has been denied the right of suffrage without ever having been convicted by a jury of an infamous crime. This is because since 1981, pursuant to Tennessee Code 402112, the state has declared any person convicted of a felony infamous and ineligible to vote, irrespective of whether that person was convicted by a jury or by a guilty plea. This violates the plain meaning of the Free and Equal Election Clause's express limit on the state's disenfranchisement authority. That disenfranchisement is only constitutionally permissible where there's been a conviction by a jury of an infamous crime. In response, defendants contend there's no conviction by a jury requirement in the Free and Equal Elections Clause. Yet defendants offer no explanation, none whatsoever, about the operative effect of the words by a jury in the Free and Equal Elections Clause, which the framers conscientiously chose to add to the provision in 1870. The framers could have said, except upon conviction of some infamous crime. They didn't. Instead, they chose to say, except upon conviction by a jury of some infamous crime. The only reasonable explanation is that the provision means exactly what it says and imposes a jury conviction limit on the state's disenfranchisement authority. In an attempt to evade this conclusion, defendants essentially propose reading the words by a jury out of the Constitution. But that amounts to an invitation to abandon unambiguous Supreme Court directives, including those articulated in the McNabb decision this past spring, regarding how courts are to interpret the state's Constitution. Simply put, the Free and Equal Elections Clause imposes a clear, unequivocal, and mandatory limit on the state's disenfranchisement authority, which defendants exceeded in denying Ms. Moses the right to vote based on criminal convictions secured by guilty pleas. And to facilitate this court's interpretation of the Free and Equal Elections Clause, I'll briefly address what the Supreme Court touched upon in the McNabb versus Harrison decision as to how Tennessee courts are to interpret the Constitution. It explained that courts shouldn't speculate on the subjective intentions or motives of drafters. Instead, they must determine how a reasonable reader, fully competent in the language, would have understood the text at the time it was issued. And so courts should begin with the text and give terms their ordinary and inherent meaning. And critically, the court emphasized that courts should presume that every word, not just some words, the drafters use has a specific meaning and purpose. In other words, courts are to avoid interpretations that render words meaningless. Applying these principles of constitutional interpretation indisputably results in the conclusion that the Free and Equal Election Clause imposes a jury conviction limit on the state's disenfranchisement authority.
Is it your position that that's not waivable?
Yes, Your Honor, for a couple of reasons. First, it's not waivable because the Free and Equal Elections Clause is a structural limit on states' power. Second, even if Ms. Moses could waive a structural limit on the state power, she did not do so. And third, the state cannot do indirectly what it cannot do directly. That is,
I guess what I meant, and I understand your argument that she didn't knowingly waive her right to a jury trial, but am I hearing your position is that no one can waive their right to a jury trial?
Your Honor, Ms. Moses isn't litigating whether or not she waived her right to a jury trial. What defendants are arguing she waived is the jury conviction limitation of the Free and Equal Elections Clause in Article 1, Section 5.
Isn't that the same thing?
No, Your Honor. Article 1, Section 6, the right to a jury trial, is a personal right that is conferred for the benefit of an individual criminal defendant. It's part and parcel of the criminal trial process, and it has to be waived in order to actually effectuate a guilty plea. What we're looking at here in Article 1, Section 5, the Free and Equal Elections Clause, it's not a right just conferred for the benefit of an individual, but to both protect the individual and the public by ensuring that elections remain free and equal. And there is binding precedent that this is not just a personal right, that it's a structural limitation on state power. I mean, looking at the language itself, shall never be denied. It's speaking about the denier and the authority of the legislative and executive branch. But back to your question, Your Honor, the Supreme Court has already held in the Gaskins decision that Article 1, Section 5, we're dealing with a limitation on the power of government. In the Gaskins decision, it said Article 1, Section of the 5, it prohibits the General Assembly from disenfranchisement under certain conditions. And then in the Crutchfield decision from the Tennessee Court of Appeals, it talked about how the legislature is empowered to deprive criminals of the right to vote under the limitations set out under Article 1, Section 5. And that's what we're getting to when we say that the Free and Equal Elections Clause, it imposes a structural limit on the government's power that cannot be waived. We're not discussing whether or not Ms. Moses waived her right to a jury trial. That's not what is before the court today. Defendants, Your Honor, are trying to conflate the two. But if you look upon the plea,
If he had had a jury trial in this case and had been found guilty, would we be here or would you have the same argument?
Our Free and Equal Election Clause claim here is dependent upon the proposition that she was never convicted by a jury. So Your Honor, no, we wouldn't be here today bringing this claim if she had been convicted by a jury of an infamous crime. Our claim is fully dependent on the fact that she has only been convicted of infamous crimes by plea agreements. So to our first point on waiver, Your Honor, it's well settled that a person cannot, while a person can waive a personal right conferred for her benefit, a person cannot waive a structural limit on the state's authority, such as the boundaries of a power of a branch of government, which is what we're dealing with here when we're talking about the Free and Equal Election Clause. Despite claiming there's precedent for waiver of a structural limit on state power, defendants have not, in fact, identified a single case supportive of the proposition that an individual can waive a structural protection that restricts the scope of power of a branch of government. Not one case, whether from Tennessee or elsewhere. And defendants are essentially inviting this court to be the first court in Tennessee, and as far as we are aware, anywhere in the country, to conclude that an individual can expand the boundaries of a power of a branch of government through a one-off waiver of an express constitutional limit on the authority of a branch of government. To the contrary, the Tennessee Supreme Court has already recognized that an individual cannot confer power upon a branch of government that is expressly withheld from it by the Constitution. An example of that would be the Barthel versus Ackman decision, in which the Supreme Court held that an individual can't waive the subject matter jurisdiction limitation because it relates to the authority of the judicial branch to hear a case. And that's a good example of, even though two different types of limitations, subject matter jurisdiction and personal jurisdiction, they both generally relate to jurisdiction, but they're different species of rights. Personal jurisdiction goes to a protection that's afforded to individuals so that they're not hailed into court into a jurisdiction that they didn't submit to. But an individual can waive that because it's a right for their benefit. Subject matter jurisdiction is a more broad issue. It pertains to the authority of the judicial branch to hear a case, and it's well settled that subject matter jurisdiction isn't waivable by an individual. An individual cannot, on a one-off basis, expand the power of one of the branches of government. And as the Supreme Court explained in the Brown versus Brown decision, considering the state derives its powers from the law, not a particular person, it necessarily follows, therefore, that constitutional authority cannot be conferred or enlarged by waiver, consent, or estoppel. However, even if Ms. Moses could waive the jury conviction limitation imposed by the Free and Equal Elections Clause, she didn't. In Tennessee, there's a long-standing presumption against waiver of constitutional rights. In order for waiver of a constitutionally granted right to be valid, it must be knowing, voluntary, and intelligently given. And here, defendants cite no evidence, and none exists, that Ms. Moses knowingly waived her right not to be disenfranchised without a jury conviction.
Didn't she have, though, an opportunity under the Post-Conviction Procedures Act to challenge the voluntariness of her plea and that statute ran?
Your Honor, under our current claim, Ms. Moses isn't challenging the voluntariness of her plea. What she is asserting is that in making that plea, she did not waive this structural limit on the government's disenfranchisement of power to disenfranchise her absent a jury conviction.
But under your theory, it wouldn't matter if she had known or not. Is that correct? You're saying she can't waive that, period. Is that what you're saying?
That's correct. That's her primary position, Your Honor. She can't waive that period.
Then what difference does it make if she entered her plea knowingly waiving that or not? Even if she had been told under your position that you understand by entering this plea, you will never be allowed to vote again, even if she had been told that, your position is that doesn't matter. Is that correct?
No, Your Honor. When I refer to the knowing and voluntary standard, I'm speaking to the standard for waiver of a constitutional right with regards to Article 1, Section 5. We're not disputing whether or not she waived her right to a jury trial, her personal right to a jury trial under Article 1, Section 6, whether that was knowing and voluntary. We're arguing, one, she could not waive the structural limit on the state's disenfranchisement authority under Article 1, Section 5. But two, even if she could, there was no knowing and voluntary waiver of that right. We're not talking about the right to a jury trial.
No, we're talking the same thing. I just want to be clear on what your position, even if she at the plea colloquy had been informed that by entering this plea, she was waiving her right to ever vote again. You're saying that she could not do that. Is that correct?
Yes, Your Honor, because the shall not be denied except upon conviction by a jury is a structural limit on the state's disenfranchisement authority. That's our position. But, defendants say that she was made aware and of the consequences on her voting rights through her guilty plea, but defendants really can't have it both ways. It's untenable for them to suggest that Ms. Moses was made aware of the free and equal election clause related right that defendants say she knowingly waived when the state has yet to recognize such a constitutional right or limit even exists. In other words, defendants are arguing here today that there's no jury conviction limit on the state's disenfranchisement authority, so they cannot possibly say that Ms. Moses was informed that by pleading guilty, she would be waiving such a constitutional limit on state power. But that is exactly what she would have needed to have been told in order to have had an intelligent and knowing waiver of that constitutional right. And nothing in the written plea forms and judgments says anything about voting or the free and equal elections clause. The only evidence that defendants cite is related to the discussion of waiver of her right to a jury trial under Article 1, Section 6, which is an entirely different constitutional right. If you look at the judgment form entered upon her guilty pleas, they go one by one on the rights that the judge found Ms. Moses had waived. They go through the right to a jury trial. They go to the right to have a jury fix a fine over $50 under Article 6, Section 14. There's no mention of the free and equal elections clause in Article 1, Section 5. And if it was waiving your right to a jury trial, waived every jury-related right, there would have been no reason for the court to go one by one and also look at whether Ms. Moses had a knowing and intelligent waiver of the right.
Was she declared infamous?
Under Tennessee Statute 2112, anyone who's been convicted of a felony is immediately declared infamous and disqualified as a voter immediately. And that's what we're challenging here today, because that law does not take into account the by a jury language that is a restriction on the state's disenfranchisement authority. And finally, this court should reject defendants' proposed theory of waiver because it would make it trivially easy for the legislature to render a constitutional provision meaningless. On their theory, the legislature could pass a law stating that anyone who pleads guilty to a crime loses their rights to free speech forever. And then they would say that no one can challenge that law because anyone who pleads guilty has waived their constitutional right to free speech because of the existence of the statute and the fact that they're deemed to be aware of it. Or they could pass a law saying that anyone who pleads guilty to any misdemeanor, including jaywalking, would lose their right to bear arms protected by the Constitution. And then they would say that no one can challenge that law because by pleading guilty, you automatically waive your right to argue that the statute's unconstitutional. Those results make no sense, and for the same reason, the legislature just can't pass a law saying that everyone who pleads guilty loses their right to vote and then argue that that law is immune from constitutional challenge because everyone who pleads guilty is deemed to have waived the right to vote and have waived the right to challenge whether or not the state complied with the express restriction on their power. I know I'm running out of time here, Your Honors, but to briefly circle back to the fact that there is this jury conviction requirement imposed by the Free and Equal Elections Clause, the defendants don't analyze the text at all. They try to avoid it, and they try to rely on a Gaskin's decision, which was relating to a different part of the Free and Equal Elections Clause. They don't dispute our evidence that by a jury means what you and I would think by a jury means today, by a group of an individual's peers from their community. They're trying to write the by a jury language out of the Constitution in blatant disregard of well-settled Supreme Court precedent that Tennessee courts should avoid reading words out of the Constitution and rendering them meaningless. I'm happy to take any questions that you might have, Your Honors. Thank you very much for your time.
All right, thank you, counsel. Who's going to argue for this state, for the defendants?
Sorry to say, it's still me.
Okay, all right, counsel, you go right ahead. You may
All right.
proceed in it. It's
And
55.
yes, and I would rather argue slowly the important things than quickly this time. I will quickly say that, to begin, for all the reasons already stated in the prior argument, we don't think this is a claim in this lawsuit, much less one ripe for summary judgment consideration. Moving past that, I want to focus on waiver. I want to point out Article 1, Section 9, or no, Section 8 of the Constitution. No man shall be taken or imprisoned or disseized of his freehold, liberties, or privilege, or deprived of his life, liberty, or property, but by judgment of his peers. That is a restriction upon the state's power. We have for hundreds of years allowed people to waive that in plea agreements. Let's compare that to Article 1, Section 9, that in all criminal prosecutions, the accused hath the right to be heard by himself, to demand the nature and the cause of the accusation against him, to meet the witnesses face to face, to have compulsory process for obtaining witnesses in his favor, and to a speedy public trial by an impartial jury. Those are not limitations on the state, but grants of rights to criminal defendants. The Supreme Court has also said they can waive those. And so the Supreme Court's been very clear. Criminal defendants can waive limitations on the state, and they can waive rights conferred upon them. I want to differentiate that from what Mr. Peterson got at. What parties to a lawsuit can't waive are the jurisdictional limits of a court, because jurisdictional limits of court are constitutionally established and not up to parties to edit. So this is different than that. And in fact, I'll tell you, the primary waiver case is State v. Johnson. It's a 1978 Tennessee Supreme Court case. And it talks about defendants' abilities to waive both the trial and all the things that accompany a trial. And Your Honor, I'm going to quote from that case. It says, initially, we observed that Tennessee has specific disability statutes, which designate a particular civil disability that occurs upon the conviction and remains in effect throughout the defendant's life unless restored by a specific statutory procedure. Specific disability statutes include the loss of the right to vote. The Johnson case that the Tennessee Supreme Court was writing about was in fact a case in which the defendant, Johnson, pled guilty. He was not convicted by a jury. And so the Supreme Court, while not squarely speaking to it, has looked at a defendant that pled guilty and has said the civil disability of the loss of right to vote is perfectly fine. So we would submit that the Supreme Court already said you can waive this. It's already, in Johnson, demonstrated a case that it was perfectly okay with that civil disability after a plea. The second thing I want to say is there's a difference between limiting the state's power and limiting a person's power. We're using the word waiver, or they did, because that's beneficial to their client. What really happened here is, knowing the civil disability that came with the law, because we're supposed to presume she's aware of the law, she surrendered it. She didn't waive it. She said, should have understood the ramifications of pleading, and she said, I choose to plead. I choose to accept what comes with that. I am waiving my constitutional right to a jury trial, my right to compel witnesses, my right to confront my accusers. I'm waiving all of that, and I'm choosing to accept the consequences. She surrendered it. And so, Your Honor, it's waiver is okay, and surrender is certainly okay. Now, this idea of knowing, unknowing, it's just repackaged procedural due process. This court's already ruled on it. I got plenty of time now, almost done. The last thing I want to differentiate is Mr. Peterson made some arguments about, free speech and what this could mean and the slippery slope. Your Honor, there's a much bigger difference. There is no provision of our Constitution that says the legislature can pass a law that takes away free speech rights of felons. There is a law that says once someone is declared infamous, they lose their right to vote. That's constitutionally guaranteed. It's a constitutionally authorized ballot. That the slippery slope that's dangerous here is right now for the administration of justice, we allow people to admit to crimes, often lesser crimes than they've been accused of. If what plaintiffs want to have happen happens here, imagine that justice system. All of a sudden the state's hamstrung if they don't want these people to vote, they're going to demand trials of everybody. How many more judges are we going to need? How ridiculous is it to say that people can't, for their own benefit, plead to a lesser because we're going to bar them from giving up their right to vote? They've created an untenable situation in this constitutional interpretation. So, Your Honors, absent questions, I think I'm done.
Well, I have a question. Consider the flip side of that, because I was thinking as both of you were speaking about the public policy behind the language in Article 1, Section 5, which has that jury requirement. What would be the public policy requirement to specifically include conviction by jury? Because we know that oftentimes people will plead guilty on advice of counsel who are not necessarily guilty, but they consider the consequences, the risk, and they make a calculated decision many times to plead guilty. Whereas if you are tried by a jury of your peers and you have all the constitutional protections associated with being a defendant, and then you are found guilty of a felony, then you fall squarely within the language of the section of the Constitution. So, and I guess my other question would be, well, that was a comment, but my other question would be, when a defendant, and I don't do criminal, I'm not a criminal court judge. I strictly have circuit or civil jurisdiction. But I do know a little bit about the criminal process from having been a lawyer for 18 years. And when a defendant signs off on their guilty plea, there are certain rights, and I think Mr. Harbinrick addressed those rights earlier, if I'm not mistaken, that are listed, those waivers. And they clearly sign off, they waive their right to a jury, they waive the rights, all of those rights. But what is different about this case is that they don't waive the right to give up their right to vote if they are not convicted by a jury. For example, if they plead guilty, they are not waiving their right to be disenfranchised, but for being convicted by a jury. So if the Constitution says that, why not have a provision if you contend? And I'm not saying that the right can be waived, because Mr. Peterson is arguing no, it's not a waivable right. But if it could be waived, would it be important to have that specifically outlined in the guilty plea itself, like many of the other rights are? And that's my question for Mr. Healy.
Sure. And I'll try and address both. On the public policy issue you brought up, I don't mean this to sound callous, but we don't rank rights, right? We're not going to rank your freedom and voting. That's tough to do. But we've decided, and the Tennessee Supreme Court has sanctioned, we allow people to waive their right to freedom. We do. They plead guilty. We know those are legal in Tennessee. To argue that is somehow lesser than allowing them to waive their right to vote. I mean, the right to vote is important, but being out of jail is probably more important. And so as a policy, this state's okay with that waiver. Now, as to the second question, and this gets to what I was reading from State v. Johnson. So the things that they are apprised of, that you need permission to waive. In other words, the colloquy the criminal court judges have. Those are different. Those are procedural safeguards, right? They're not a punishment. A right to a jury trial is not a punishment. A plea of guilty allows you to waive those procedural safeguards and then accept the punishment that's coming to you. The right to vote, the loss of it, and the Johnson case makes this clear. It's not a procedural safeguard, and it's not a punishment. It's what the court has called a quote, specific disability statute. It is said that they don't need to be advised of it during that colloquy because it is not a punishment. It is something that accompanies a conviction.
Right.
And so because it's a specific disability statute, it gets a different status than these other things that we were talking about, these procedural safeguards.
In the Johnson case, did the court ever look at Article 1, Section 5 in their analysis?
They did not mention it. They did specifically mention that Mr. Johnson pled guilty. And they specifically mentioned that by pleading guilty, he faced the specific disability statute of 40-2112 of the loss of the right to vote. And it was a 2002 case. It's not that old.
So if that issue was never raised, then how would that case have any precedent if they were just looking at whether or not the right to vote was a civil disability, if the constitutional issue was never raised?
Your Honor, I would only say that you are correct in that there's not a sentence where they say we find that this does not violate the free and fair election clause. I would say that our Supreme Court in 2002 was quite aware of the Tennessee Constitution and what it said, and it was faced with this exact situation, and it allowed a man who pled guilty to lose his right to vote. And I've got to think that those justices knew what they were doing, and we're aware of the Declaration of Rights in our Constitution that's been there for over 150 years, 200 years.
All right, well, Tennessee's constitution is different and our statutes are different. In some states, you are automatically reinstated upon finishing your sentence. If you're a felon, automatic reinstatement, you don't have to apply for anything. In other states, you have to jump through certain hoops. And in some states, you have permanent disenfranchised statutes, such as the one that we're dealing with here. And in other states, there are not. So each state is different. Each state constitution is different. So, I mean, we just have to look at the Constitution, the statutes, and try to apply them as best that we can. Do the other judges have any questions for the attorneys?
I do. What's the citation to that Johnson case?
Yes, Your Honor, it's 79 Southwest 3D 522, and the quote I read appears on 527.
Did you say 7979 Southwest 3rd 522?
Yes, ma'am.
Okay. Thank
Yes,
you.
Your Honor. And I think I did have just 2 more minutes of time, and I just want to say one thing that'll take one quick second. The idea that pleas were in anyone's head in 1870 when they said trial by jury is just wrong. In Tennessee, until 1965, when a statute was passed, you could not plead guilty to a felony. In other words, in 1800s, when this constitutional provision was added and it said convicted by a jury, there was no other way to commit an infamous crime. You could not plead to an infamous crime in the 1800s. It wasn't until 1965, and the Supreme Court case discussing it in 1968 is Seal v. Luttrell, I think. And in that case, the court makes clear that prior to 65, you could not plead to a felony. You could not be rendered infamous any way other than a conviction by a jury. And so I hate saying this because we're not supposed to, but the language in the Constitution in the 1800s was the only way that people drafting it understood being infamous could happen. It was by a jury.
So in terms of our case, then how would that apply? Should the Constitution have been amended, or are we supposed to not read the language of the Constitution? I mean, it's not statutory interpretation, what the legislature intended. It's the Constitution. It says what it says. So should Tennessee have gone back and sought an amendment after, 1865?
1965. I think the answer is, and I was more directing what I was saying to a question that was asked, why would that language be there? That was asked. And the explanation for why that language is there is because the only way to be convicted of this crime at that time was via trial by jury. And so they wanted to be very clear. You can't do it for commission of a misdemeanor. You can't do it because you feel like it, like King George was doing it. You got to be convicted of an infamous crime by a jury. And as they understood it in 1830 and 1860, that was the only way to be infamous. Starting in 1965, the legislature gave criminal defendants the right to plead to infamous crimes.
All right, any other comments, questions?
Your Honor, would it be possible to still claim my 2 minutes for a very brief rebuttal?
Any objection, judges?
No objection.
Okay.
Thank you, Your Honors. To keep it really brief, there are a couple of points that I'll just rattle through quickly. First, the notion that the Supreme Court has ever weighed on whether or not there's a jury conviction requirement. It simply hasn't. This issue has never been placed before the court before, and it's not the court's role to innovate theories that lawyers hadn't brought before them. This is an issue of first impression, and it's plaintiffs' interpretation of the Free and Equal Elections Clause that's in accord with the tools that the Supreme Court articulated in McNabb should be used to interpret the Constitution. And the Gaskin Supreme Court decision, in fact, did acknowledge the jury language in the Free and Equal Elections Clause, noting that you can't have retroactive disenfranchisement. It's when the jury conviction happened, it said that's by when the crime had to be declared an infamous crime. And second, I'd like to address the notion that guilty pleas weren't in existence at the time of the amendment of the Free and Equal Elections Clause. I'd like to point Your Honors to our briefing. They certainly were in existence for misdemeanors. Defendants are putting the cart before the horse by saying there was no convictions by jury for a felony. The drafters of the Free and Equal Elections Clause said infamous crime, and they left it up to the legislature to define infamous crime. It later was defined as felony, but at the time, it wasn't in the provision itself. The framers were very well aware of the fact that jury convictions, that there were convictions by guilty plea. In fact, the Supreme Court overturned a guilty plea in 1865 in the Swang decision, not because it was a guilty plea, but because it was coerced. So the Supreme Court was aware that guilty pleas were in existence. The drafters of the Constitution were as well. And finally, on the waiver point, Your Honors, while it's our position that it can't be waived because it's a structural limit, even if it could be waived, defendants have not met the high burden of proving waiver of a constitutional right. If you look here on the order on Ms. Moses's guilty plea, it rattles through the rights that the court determined that she intelligently and understandingly waived. It went through the right to have a jury determine her guilt and to fix her fine in excess of $50. There's absolutely no mention of the Free and Equal Elections Clause or any voting related consequences. So we'd argue even if she could waive the limit, and we disagree that there's any support for the notion that an individual can waive a structural limit on state power in the way that defendants have characterized it. There simply is no evidence to find a waiver here. And that's all that I have, Your Honors.
Appreciate you trying to get that in within 2 minutes, but I just want to ask you to repeat because I think I understood, but I was having a little bit of a difficult time following the argument with regard to the timing of the statute that allow individuals to plead guilty to felonies versus the enactment of Article 1, Section 5, and the ability to plead guilty to misdemeanors. So try to slow that down a little bit and walk us through that.
Sure, Your Honor. So the Free and Equal Elections Clause added this jury language in 1870. Prior to this time, the Tennessee Code expressly authorized convictions by guilty pleas in certain circumstances. For instance, there were certain gaming offenses where you can plead guilty and have, a certain justice of the peace, decide upon the punishment. So the fact that there were guilty pleas for certain crimes in existence suggests intentionality behind the drafters' usage of the word conviction by a jury. They were aware that there were certain circumstances where there weren't convictions by a jury. Defendants make the point that, oh, there weren't convictions by a jury for felonies at that time. But again, what the Free and Equal Elections Clause says is conviction by a jury for an infamous crime, and they left it up for the Assembly to define what that meant. The Assembly could have defined infamous crime as misdemeanor crimes. It didn't, obviously, but the framers of the 1870 Constitution were aware of convictions by guilty pleas, and we think that suggests intentionality in the phrase conviction by a jury. And at the end of the day, defendants did not dispute that contemporaneous dictionary definitions and contemporaneous usages of the word jury in court suggests jury means jury. And if you look at the Free and Equal Elections Clause, it mentions conviction by a jury and a judgment thereon by a court. Even the Free and Equal Elections Clause itself envisions two distinct actors involved in part of this process to permit the state to engage in disenfranchisement. There's a conviction by a jury, and then there's a judgment thereon by a court. And defendants are essentially asking this court to conflate the two and just say there only needs to be one actor as part of that process before the state can go ahead and take away the fundamental right to vote. And we submit that's not in accord with the plain language of the Constitution.
That second part of that constitutional section means, did you say a judgment by the court?
Your Honor, the Free and Equal Elections Clause mentions there must be a conviction by a jury, an entry of a judgment thereon by a court. So even the framers of the 1870 Constitution referred to the jury and court in a distinguishable fashion. They didn't conflate the two. They were specifically referring to the jury as the contemporaneous dictionary definition suggests, which is a group of members from one's community, and then an entry of a judgment thereon by a court. And defendants are essentially asking this court to conflate the two and say that the court can be the one that enters the conviction and enters the judgment, but the Constitution requires more than that before the fundamental right to vote can be taken away.
All right, well, thank you for answering that question. Any other questions, judges?
No.
Okay.
No.
All right, very good. Well, we want to thank you all. It's been some very interesting arguments today. I think both sides did an excellent presentation. And thank you all for adhering to the time constraints. Of course, we are going to deliberate and we will get that decision out as soon as possible. So if there's not anything else, we will stand adjourned for the evening.
Thank you.
All right, thank you. Thank you very much.
Thank you.